but McQueen has another case with a different lawyer.
Okay.
So we'll still need McQueen at some point, but for Mr. Klein's.
Okay.
All right, and then you have Mr. Austin,
Yes,
who's
sir.
in special housing as well. Not here yet, so we'll call you back up when they get here. All right, Mr. Stewart.
Good morning, Your Honor. Stewart.
Morning.
May it please the court, Your Honor, Brad Stewart, on behalf of Mr. Comey, Judge. We have approved Mr. Comey for Phoenix
Phoenix
House at
House.
this time. The state is touching base with the alleged victim in the case, Judge. For the record, this is 26 CF 145, Judge.
Isn't there another case, it's a VOP?
I
But,
believe there's a VOP running along with this.
and I think Mr. Welton was handling it, but you were also on,
I believe I filed a notice of appearance because we visited that last time, if I'm not mistaken. I believe my office perfected that, Judge.
yes. Yes, you're both listed on it, at least on here you are, on mine. I don't think there's room for it on the paper docket, but,
Very good, okay. And Judge, if we could put both cases on the 901 docket, I think something may shake loose. We'll be able to bring this in for a landing.
all right. September 1st at 9 o'clock, hopefully to get that resolved.
Very good. Your Honor, that's all I have. May I be
All right,
excused?
yes, sir,
Thank
thank
you,
you. Mr. Ramey?
Judge, I don't, one of Mr. Raines' special housing, and I'm gonna ask to take one out of order real quick because that will free up space for special housing to come upstairs. That'll be Kevin Smith with Miss Rivers. He's on the way out.
Oh, gotcha, juvenile.
And they won't have a place to be.
Ms. Rivers, can you handle Mr. Smith?
If the court will give me just a moment to pull up the case number.
I feel this is very like Ocean's 11, like they're just replaying like old footage. There's nobody there, but meanwhile, people are doing things.
We're almost done for this. Smith, come on out. You can either stand on the blue X on the corner.
Oh, good. Your Honor, this is Kevin Smith before the court on 25 CF 2239. Mr. Smith is currently in a Department of Juvenile Justice program down in Central Florida. Two evaluations have to be accomplished before we can go forward on his case. And
You can't get them done in the program.
yes, the officers there keep changing. So we keep having new people, keep having to make the request through new people, and it hasn't happened. Based on allegations that are made by family members, or we have to get these evaluations done before we can proceed. How long have you been in the program now?
6 months.
6 months, so he only has 3 more months before he'll be through with this program. I will try yet again with the latest person to see about getting these evaluations done. The other thing is to see if Dr. Zeman or Dr. McDonald will agree to do it via video, and to see if we can get that scheduled and do it that way, since it's not happening down there.
Okay.
It's-
Is the case for which he's in the program from Okaloosa County or from somewhere else?
He's in the program based on this allegation.
Well, how's he been?
He was in a program here in Okaloosa County.
Okay.
He's alleged to have committed a battery while in the program here.
That's what this case is.
Yes, but that violated that program he was currently in here, so they've resentenced him to another program.
But is that case that sentenced him to that program an Okaloosa County case? That's what okay. That's what I felt was the answer, I just didn't want to assume that. Where is that case from, do you know?
Polk County, Your Honor.
I guess communicate with the doctors to see if they can do things remotely. And I hate to drag this out until he's done with that program just to come back up here, but I'm also looking at the fact that he's 19 years old now. All right. So what are you asking to have done? Just put it in October?
Yes, Your Honor, we would ask to continue it to the October docket.
Do you want to, depending on what the situation is, have him appear by Zoom possibly from the DJJ program in Central Florida instead of transporting him up here, and DJJ's down along too? I can only sign the orders that get sent to me, so I just don't think it's worthwhile for the transport unless something's going to be resolved. But to go back and forth doesn't make a whole lot of sense. So I'll put him on the October 28th date. But again, if you can work it out with them, obviously you're having issues with classification or whatever they call it down there, to get these evaluations done, but if they can at least prevent a lot of transportation costs, let's do that. 10/28, 9 o'clock. I didn't even see her.
Carla said she's reaching out to John.
Yeah, I saw she was trying to remote in. All right, are we back to Mr. Ramey?
I've got one with Mr. Ramey, and then I'll let you know when the special housing is up, but we can handle Noah Brake. And then I'll have Ms. Dudley lined up for all the 2 acres.
Good morning, Your Honor.
I'll take your word for it.
Just, they gotta get the email out,
Sir.
which I don't know that he's still
I think because he's in a program, he's still treated as a juvenile, even though he's 19.
Your Honor, may I please the court, Russ Rain on behalf of Noah Brake, case number 26-151. Ms. Gliss and I had some depositions last week. 3 or 4 of the witnesses failed to appear, so Ms. Gliss and I are in the process of getting those depots rescheduled. Looks like that'll probably be sometime in October, early November. Would ask to move it to the 10/28 docket.
All right, who's covering for the state? Any issues with that?
Yes, no issues, Your Honor.
Okay. All right, October 28th, 9 a.m. for Mr. Brake.
Thank you, Your Honor.
I think you're gonna have to wait on your other one.
Stand on the blue bag.
You know, this is Jacob Gabani. (25 CF2031 and 25 CF380). We have deposition scheduled for Friday. I would ask to continue this, and then I expect to have a motion to
Suppress.
filed.
I think
and
that's
get it
what
set
you
for
talked about
approval.
last time, yeah.
Yes, sir. I have got some dates from the clerk, so once we get them those depots, I will get that scheduled.
Are those depots on both cases?
Yes, sir.
Okay. All right, we'll get your motion filed if that's what you ultimately are going to do, and then get it set before that next pretrial, which is going to be again October 28th.
Yes, sir.
9 a.m.
I did get the dates from the clerk, so I know some dates that I can reach out to your JA once I get done on Friday.
I think you can book them directly with the
There was
clerk.
one on the 10th, and they said I just need to get it approved.
Oh, I think the issue is the 10th. We've got 3 or 4 set on that afternoon that are going to be long ones.
Yes, sir.
So I didn't want to put too many more people on there because we don't want to be here till 7, 8 o'clock
Yes, sir.
again. I'm sure you don't either, but,
I'll find a date and I'll get it scheduled.
all right, thank you.
Mr. McLean.
Your Honor, this is Interius McLean in 26 CF 248 and 26 CF 658. If we can just leave this set for docket day, clear continuance.
All right, what else needs to be done on Mr. McLean's case?
We are setting depots, but the state's going to try to reach out to the victim. We have received the email, but the state has not been in contact with her.
Is it the same alleged victim in both
Yes, sir.
cases?
Yes, sir, it is. And I did get a statement yesterday from a witness, so I am going to provide that to the state today.
All right, state? Who's on McLean?
I have the case. We talked to the victim. I need to talk to him. That's why I asked her if she could bump it till Monday, or the first, whatever day that is. I apologize.
That's the first.
Okay.
Oh, I'm sorry, no, you're right, it is Tuesday.
So if we could bump it till then, I will get a hold of the victim. I have a note on here that says victim wants to drop charge, but I don't know where that came from. I don't know. I know it's my secretary's handwriting that wrote it. That's all I know. If she talked to
All right, September 1st, 9 o'clock, plea or continue. The cases aren't terribly old.
Yes, sir.
Mr. Prince. Nice to turn to this judge, please.
Your Honor, this is Connor Prince in 25 1620. I have asked the state to look at this one. I know Mr. Sheik was not the attorney at the time of the pretrial detention. If we can leave it set for docket day.
Are you on his other case?
Yes, sir, I am.
Okay. Just wanted to make sure, I know that's not on today's
I think they're
docket.
set for the October date.
It's already set for October, I just didn't remember if you were on it or not.
Yes, sir, I am.
Okay. Mr. Sheik,
No objections, Your Honor.
you just want to put it on the first to see what y'all want
Yes,
to
sir.
do
Yes,
about potentially resolving it?
Are we going to put all of them on there just to?
I think just
track it
the,
Just this
together?
one.
just this
Just
one, the
this
other
one,
one's going to
okay.
stay in October, it's a brand-new case.
Thank you.
All right, September 1st, 9 o'clock, plea or continue.
Your Honor, this is Adam Sheets in 25 CF 2249. I think last time we were here, I mentioned how the discovery came. Still hasn't been corrected. We can leave it for 9-1. I will have a motion to compel filed or a motion to dismiss.
What's
based on the
missing?
information that I have.
I know you had talked about a motion to dismiss, what discovery is missing?
So the discovery that we have doesn't have, a lot of it has draft on it.
Oh, I'm sorry, say that-
Draft went across the top.
It says
And
draft.
It has like this much information. There's not a lot of information as far as when they served the search warrant. I can look at body cameras, so I figured out that there's not a lot of evidence. It looks like there was less than 1 gram found. The co-defendant has already pled to that. It was found in her purse. So he's charged with possession with intent to sell for that. My understanding, I don't see anything different than that I have in my,
All right,
in discovery.
is this yours, Mr. Sheik?
May we approach, Your Honor?
Sure.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, September 1st, 9 o'clock.
Mr. Steele.
Yeah, if I can have 1 second for Mr. Steele to sign up.
Sure, no problem.
We still need to get a score sheet for the VOP, but it won't, yeah.
Your Honor, if I may approach.
Yes.
Your Honor, this will be a plea in,
I'm
oh, yes, sir.
just, there's just a lot of chatter from every angle. If y'all could kind of just keep it down a little bit between the radio and the talking. It was just hard to hear you, Ms. Dudley. Go ahead, I'm sorry.
Your Honor, in 26 CF 451, this will be a plea to a lesser included battery. And in 2012 CF 1876, it'll be an admission to the VOP. 4 months county jail on the battery and time served on the VOP. It would not be a downward departure. He has served more time than he scores.
Okay, do we have
The state-
guidelines? You're
Adjusted,
doing
yeah.
them? Okay, I just want to make sure that they're coming at some point. All right, Mr. Steele, can you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Steele, can you state your full name and date of birth, please?
Derek Jamal Steele, 3195.
All right, and Mr. Steele, you're here on a VOP in 12 CF 1876, as well as a new case of aggravated battery where you're currently charged aggravated battery in 26 CF 451 as a second-degree felony punishable by up to 15 years in the state prison. Do you understand that?
Yes, sir.
All right, I have a plea in the sentencing agreement between you and the state that calls for you to admit your violation of probation. In the 2012 case, it'd be an adjudication of guilt, time served, revoke and terminate your probation, $100 VOP fee, and your cost to judgment. In the new case, it would be to a lesser included offense of battery. That's Florida Statute 784.03, paragraph 1, subparagraph A1. There'd be adjudication of guilt on that first-degree misdemeanor, $622 in court costs. Can you verify that? 4 months county jail credit for time served, and you believe he has that amount of credit? Is that what you're saying? Okay. Is that your understanding of the agreement, Mr. Steele?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
Okay, and Mr. Steele, have you had enough time to go over this agreement with your lawyer?
Yes, sir.
And did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just went over?
No, sir.
And do you understand that in the new case, if you enter the plea to the misdemeanor battery, there won't be a trial of any kind?
Yes, sir.
And you understand you're giving up your trial rights, which are on page 2 of the agreement that you signed and said you understood?
Yes, sir.
And you understand that on the violation of probation, if you admit your violation, there won't be a hearing where the state would have to prove how you violated your probation?
Yes, sir.
And you understand you're waiving any potential defenses you have in both cases.
Yes, sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country.
Yes, sir.
All right, now what is your plea in 26 CF 451 to the lesser included offense of misdemeanor battery?
No contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given. That's going to be adjudication of guilt, $622 in court costs, 4 months county jail with credit for time served. Are those costs going to judgment as well?
Yes, sir.
Okay. And then in 12 CF 1876, what is your plea to the violation of probation? Are you admitting or denying your violation?
Meeting.
I'll accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, sentence you to time served, revoke and terminate your probation, $100 VOP fee, and all those costs will go to judgment as well. Mr. Steele, I will need your fingerprints, even though it's a misdemeanor, it's a battery charge, which is enhanceable, so there has to be fingerprints for that purpose. And then you have 30 days to appeal the judgment and sentence of the court. Is there anything that I've missed? All right. Thank you very much. Thank you, Mr. Steele. Step up to be fingerprinted.
Your Honor, may I approach?
Yes, sir. Oh, and these are the guidelines. I am reviewing them. Any objections to the guidelines? Did you see them? Well, hold on. You said it is a downward departure.
So,
I mean, he served 10 years already, so I guess that's all.
yes, it is a downward departure, Your Honor, but
Okay.
it's.
It's a
he
downward
has served.
departure, but if I had sentenced him to what this number is, he'd still have the time served anyway.
Correct, John.
Correct.
All right, just making sure that's
Yes, sir.
clear. I still have to call it a downward departure, I believe, so plea bargain, let's see.
I believe it was 10
I'm
years,
sorry.
correct?
It was 57.15 months, but he's already served 10 years on
Yes,
that
sir.
charge.
You got it right there.
Okay. Who do we have next? Oh, look at that.
Your Honor, this is entry on Coleman in 17 CF 1004, 25 CF 2019.
All right, what are we doing with Mr. Coleman?
If I can approach him?
Yes. Who's the state? Oh, I'm sorry. You usually say that first. All right. Let's see, 25. All right, so it would be then 7 years DOC on the VOP, 5 years on the new case, right? Because it's a third-degree felony.
Yes, sir. and then we-
Concurrent, but I can't give him 7
Yes,
years
sir.
on a
Understood.
third degree, unless there's something else in play, which I haven't heard or read. All right, Mr. Coleman, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, can you state your full name and date of birth, please?
Entry on Coleman, August 22nd, 1993.
Okay, and do we have guidelines for Mr. Coleman? Y'all could take a look at those. Mr. Coleman? All right, I'll let them figure that out. We'll talk a little bit more, Mr. Coleman, while they're getting me that paperwork together. Mr. Coleman, you're here in 17 CF 1004 on a violation of probation, underlying second-degree felony, which is punishable by up to 15 years in state prison. And then 25 CF 2019, 3 counts of failure to register, 2 on an email address or an internet identifier, 1 on a phone number. Each of those are third-degree felonies, punishable by up to $5,000 or a $5,000 fine and 5 years in state prison. Do you understand all that? Your current charges. All right. I have a plea and sentencing recommendation between you and the state that calls for you to plea to count 3 in 25 CF 2019. The state would dismiss counts 1 and 2. You'd also be entering an admission to your violation of probation in 17 CF 1004. Cost of $666 in the new case, $100 VOP in the 17 case. On the VOP, it'd be 7 years DOC with credit for time served. And in the 25 CF 2019, it'd be 5 years DOC with credit for time served. All cases and counts to run concurrent and coterminous. Is that the agreement?
Yes, sir.
your costs will go to judgment and then revoke and terminate your probation in 17 CF 1004. Is that your understanding of the agreement, Mr. Coleman? Is that what you want to do here today? Is that what you want to do here today? Okay, I think I looked over there. I was getting ahead of myself. Ms. Leone, is that the state's agreement?
It is, Your Honor.
Okay, and y'all have the guidelines there? You can keep working on them, just want to make sure I see them at some point. All right, Mr. Coleman, have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes,
And did you understand and sign the agreement?
yes,
Are you satisfied with your attorney's representation and advice in these cases?
yes,
Are you currently under the influence of any alcohol, drugs, or controlled substances?
sir.
Are you currently suffering from any mental health issues?
No, sir.
All right, has anyone forced, pressured, or threatened you in any way to enter these pleas?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read to you? All right, in the new case, the 25 CF 2019, do you understand that by entering a no contest plea, there won't be a trial of any kind? You understand you're giving up your trial rights, which on page 2 of that agreement, you said you signed and understood?
Yes, sir.
Yes, once you're ready. Any objections to the score sheet, Ms. Dudley? Looks like y'all made some hand changes. I'll take a look at those. All right, and do you understand that on the VOP, if you enter an admission to your violation of probation, there won't be a hearing where the state would have to prove how you violated your probation? And you understand that you're waiving any potential defenses in each of those cases?
Yes, sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and in 25 CF 2019, what is your plea on count 3, the failure to register a phone number?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. On 17 CF 1004, what is your plea to the violation of probation? Are you admitting or denying that?
Admitting.
I'll accept your admission as freely, voluntarily, knowingly given. In 25 CF 2019, does the state have an announcement, count 1 and count 2?
State dismisses those two counts in exchange for a plea to the count 3.
Okay. And so 1 and 2 were dismissed on the 2019 case. It's going to be adjudication of guilt. In the 2019 case, $666 in court costs. In the 17 case, it's going to be a $100 VOP fee. Be 7 years DOC with credit for all time served in the VOP, 5 years DOC with credit for all time served on the new case, the 2019 case. All cases and counts are in concurrent and coterminous. Cost to judgment, revoke and terminate your probation in 17 CF 1004. According to the guidelines, he scored 53.025 months, so this would be a guideline sentence, correct? All right, I do need your fingerprints, Mr. Coleman, for purposes of the new conviction. And you have 30 days to appeal the judgment and sentence of the court. Thank you.
Mr. Phillips, come on up, please.
Yes. Do you have Adam Phillips on your docket?
He was on Monday, Your Honor.
That's what I thought. I remember seeing his name, but he's not on the current docket, so it's going to be cases. Would have been on Monday. It's 25 CF 290. And then he's got 292, 290, 292, and then 26 CF 1300. 225 cases would be dismissed pursuant to this, or at least one of the counts. All right, I'll announce it. All right, Mr. Phillips, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, yeah. All right, can you state your full name and date of birth, please?
Yes, sir. Adam Thomas Phillips, 32486.
Okay, Mr. Phillips, you're here in three cases. 25 CF 290s aggravated battery with a deadly weapon, 15-year maximum on a second-degree felony. 25 CF 292 possession of ammunition by a convicted felon, second-degree felony, 15-year maximum, and possession of paraphernalia, first-degree misdemeanor, 1-year maximum. And 26 CF 1300, which is possession of a controlled substance, third-degree felony, 5-year maximum, and drive while license suspended or revoked is just second-degree misdemeanor punishable by up to 60 days in county jail. Do you understand that?
Yes, sir.
All right, I have a plea and sentencing agreement that's been made between you and the state that would have you plea to 26 CF 1300, both counts, and count 2 in 25 CF 292. In return, the state's going to dismiss 25 CF 290 in its entirety and count 1 in 25 CF 292. Is that your understanding of it?
Yes, sir.
Okay, and it calls for an adjudication of guilt, 615 court costs in, oops, got some numbers back. 615 court costs in the 26 CF 1300 case, 270 in the 25 CF 292 since it's a misdemeanor, 3 years of probation on the felony count, time served on the 2 misdemeanors. I have to do a substance abuse evaluation, any recommended treatment. It is an adjudication of guilt. I think I said that already, so it will be 1 felony conviction. Do you understand that, Mr. Phillips?
Yes, sir.
Is that your an understanding of the entire agreement?
Yes, sir.
And did you have enough time to go over the agreement with your lawyer?
Yes, sir.
And are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
No?
No, sir.
All right. And are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I just read to you?
No, sir.
And do you understand that by entering a plea to these 3 charges, there won't be a trial of any kind?
Yes, sir.
And you understand you're giving up your trial rights, which are listed on page 2 of that agreement that you understood and signed?
Right, yes, sir.
All right, and do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that entering this plea may lead to your deportation or exclusion from the country if you're not a U.S. citizen?
Yes, sir.
All right, and it looks like it's a guideline sentence as you scored 36.40 points. Any objections to the score sheet, Ms. Dudley?
No, Your Honor.
All right, Mr. Phillips, what is your plea to the possession of drug paraphernalia, possession of a controlled substance, and driving while license suspended or revoked?
No contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given. Does the state have an announcement on 25 CF 290 and 25 CF 292, count 1?
Yes, the state will null process those charges, Your Honor.
Okay, those cases have been dismissed by the state pursuant to the plea. In 26 CF 1300, it's going to be $615 in court costs, 3 years probation on the felony, 270 court costs in 25 CF 292, be time served on that misdemeanor as well as the drive-on license suspended. You're to do a substance abuse evaluation, any recommended treatment, Mr. Phillips. I do need you to talk to probation, who's sitting there behind you, and come up and get your fingerprints done, and then you have 30 days to appeal the judgment and sentence of the court. All right.
Yes, sir.
Thank you, sir.
I think that is all I have, Your Honor.
Everything's good. Yeah, I can see everybody now. Of course, now there's nobody on Zoom.
And then I've got Mr. Rare ready to go.
Oh, Mr. Rare. Gee,
I'll come back and get the other guys. Mr. Graham.
Morning, Your Honor. For the record, David Rare for Mr. Bryson Gurney, 26 CF 828, 22 CF 1043. We had a motion to suppress that was previously filed in the older 2 cases, but that got delayed for the new case coming through. So we're at the point to move forward on that and set that. Does the court have a hearing date to try to schedule, or he wants us to reach out to your JA and work on that? We can continue today and reach out to do that, that's fine.
let me just take a look at it again. I think, again, I mentioned this earlier. On the 10th, I've got 3 cases at 2 o'clock that will all probably be lengthy, but then again, sometimes we think it's going to be a lengthy hearing and it ends up being resolved in some way and it takes 2 minutes, but, so I could either do the 10th or knowing that it may be a longer day. I don't know, how long do you think the suppression motion will take? I have no idea what it is, so.
It's involving statements. Depending on video, I want to tell the court at least an hour. I would hope it would be shorter than that, but I don't want to short sell it.
Sure.
So,
Well, and then there's always the option that if y'all agree to me watching the video in advance and you provide it to me, I can do that, so you don't have to sit here and watch me watch the video. I'm always,
Exactly what I was gonna ask, if the court would do that.
if y'all want to do that, I think we could probably put it on the 10th.
you can, I'm fine doing it.
And then the argument will probably only take 30 minutes or less, and then we'll go from there. All right, all right. If that works, then let's put that on the 10th at 2 o'clock. Just make sure y'all take a look at a video, put it on a disc, make sure you agree to, that's the one you want me to watch, and then have it delivered to my office. That way I can take a look at it ahead of time.
And just to clarify, September 10th at 2 p.m.?
2 p.m., yes, sir.
I guess we'll just park it on September 10th for status for both those cases.
Well,
Or do you want to get?
what's the plan, regardless of what happens with the suppression motion? Are you going to be continuing it?
For now, yes.
Okay, so I'm going to put it on 10/28 for purposes of pretrial, but September 10th at 2 o'clock for the motion to suppress. Just, the other day, we had one where I didn't give it a new pretrial date and it fell off the docket, and thankfully we caught it, but I don't want that to happen to your case, especially with someone who's in custody.
Coming out now is Mr. Sean Ward, 26 CF 659. We've gotten the order and we've gotten the DCF records. Now I've gone through those. There are a total of 18 witnesses we're going to need to depose, 15 local and about 3, I believe, are out of the local area. And so we're moving forward to try and get those scheduled. So I'm asking for a 1-cycle continuance for us to coordinate those.
Okay.
No objection, Your Honor.
All right, that's going to be October 28th at 9 o'clock for a pretrial conference. Are y'all going to travel for those depositions, or is that just going to be Zoom? Or?
I'm going to coordinate that with him and his family about the expense of that versus Zoom. I prefer to do it in person, but there's some realities we got to discuss on that.
Sure. All right, sounds good. All right, thank you, Mr. Ward. We'll see you back October 28th, 9 o'clock.
And Judge, last I should have on the docket is Mr. Reginald Harrison. Mr. Harrison is out of custody now, and he's approaching. In Mr. Harrison's case, we filed a motion to suppress. We reached out to coordinate date. We haven't had a response yet on scheduling that. So procedurally, we're just going to ask for 1-cycle continuance today, but we also need to coordinate the hearing date. I don't think that's one we could add to the.
All right, so it sounds like you're going to have to go, what, late September? Oh, no. I think October 1st?
May not be here on October 1st if that's a Thursday. I think I'll be out Thursday, Friday, but later in the month I should be.
All right, October 8th?
That should be good. 2 p.m. also.
That would be 2 p.m., yeah. We try to do all the contested hearings at 2 o'clock. All right. You can certainly put it down for that day, just make sure you do a notice of hearing on that.
10/28 pretrial, 10/8 for motion to suppress, and I believe that covers Mr. Harrison's case.
I think we should have one on the first, but it's not scheduled.
Well, yeah, I see there's arraignments that day, so we'll address that with the other issues as well. All right, so October 8th, 2 o'clock for the motion to suppress, and then October 26th at 9 a.m. for the out-of-custody pretrial for Mr. Harrison. All right, anything else, Mr. Ware? All right, who else do we have?
Mr. Parnell lined up.
Mr. Parnell.
See you, Judge.
All right, you too. Thank you, Mr. Ware.
No, I think that's the only three I had in the mind. No, you just said like you're bringing someone else up for me. I had to double take that.
Good morning again.
Good morning again.
Awesome. Trey Parnell on behalf of Greg Austin. Judge, last week I filed two motions that we need to set for hearing for permission to depose two child witnesses. In speaking with Ms. Leone, we've agreed to supply the forensic videos
Sure.
to you.
Usually makes it go a little bit faster.
It consists of 3 videos, 2 interviews of one victim and 1 video of the interview of the other victim.
Okay. And I'm assuming then that the state objects to the request for the depositions?
Of the minors, yes.
Okay. How long do you think all the videos are combined? I'm just trying to,
Hour and a half.
I was going to say hour and a half.
I think this would be a relatively short argument. Do you want to put it on the 10th?
I'm fine
I
with
mean, I'm familiar with the arguments that get made with the statute. I'll have watched the videos already. To be honest, I would think about trying to put it on next week, but I just don't think I can make a promise I can watch an hour and a half of videos because I'm on duty next week too.
September 10th,
Would that work for you for
Yeah,
2 o'clock?
Yes, Your Honor.
Okay.
and you said 2 p.m.?
2 PM, yes, sir. If you could do a notice for that, Mr. Parnell, and then again, I'll watch it in the meantime. I just can't promise I can do it by next Thursday.
And Judge, a couple of other things that we had talked about when I was before you a few weeks ago.
Okay.
We did receive, finally, the transcripts of 4 DCF depositions that were done by the prior counsel. I've read 2 of those. We just got them on Thursday or Friday of last week. I'm giving a copy of these to Mr. Austin. And also, after we got some guidance from the court about getting those forensic videos transcribed, those are in the process of being transcribed now.
Okay.
So just letting you know.
All right.
The things we talked about last time.
Is there anything that you're missing as far as other transcripts or other discovery? I know you've had the case for a little while. I just want to make sure we're not missing anything else.
I'm unaware of any other, off the top of my head, of any other discovery. There are a couple of other matters that we don't need to get the court involved with at the moment that Ms. Leone are talking about that are related to the depositions that we're going to have the hearing on September 10th. And if required, I might file a couple of other motions to address that, and it shouldn't add much more time to those matters.
Okay. All right, then we'll see you back for September 10th, 2 o'clock on the motion docket at 2. And then, are you asking to then put it on October 28th for pretrial?
Do you have another date besides October 28th? Because I'm out of town the end of October.
That's the only other pretrial I've got. I mean, we have October 26th for out-of-custody people, but it sounds like that wouldn't change anything.
Well, it's kind of I'm gone the middle of that last week to the following Monday. I don't have a calendar in front of me.
Typically, we don't transport anybody that day. So if you wanted to potentially waive his appearance or...
We should know something about the depots by then. Let's go ahead and set it for the 28th, and we'll deal with it if necessary.
Let's set it for the 28th of October at 9 o'clock, and then if you need to change anything, you can certainly bring it up on the 10th.
Very good. Thank you, Judge.
All right. Anything else, Mr. Parnell?
No, I would like to see Mr. Austin, if that's possible, for a few minutes.
Thank you.
Great.
All right, thank you. Thank you, Mr.
Judge.
Parnell.
Good to see you.
You too. Have a good
Second
day.
those are yours. I beg your pardon?
You still covering for Mr. Henderson?
Mr. Henderson's matter's been resolved.
Yes. Nope.
No.
So, Henderson was representing McQueen on one case, Mr. Kleins has McQueen on his other case.
Well, I have Mr. McQueen right here. Mr. Klein wants to.
Yeah, if you want to handle it, that's fine with me. I just wanted to make sure everything got handled the way it needed to be. All right, Mr. Kleins, you've got Mr.
So I have Mr. McQueen on,
25 CF 2035.
yes, Your Honor, and I'm going to ask the court to continue this. There's about 6 depositions that we're in the process of scheduling. I have talked with Ms. Dudley. I know she represents, they're not really co-defendants, they're kind of
They're co-defendants.
perpetrators, maybe, alleged. So I'd ask to continue this. I know Mr. McQueen has a bond motion tomorrow afternoon with Your Honor, with Mr. Henderson, so.
Let me make sure then, the bond hearing tomorrow is on the new case with Mr. Henderson, but his bond's been revoked in this case.
It has not been revoked.
It's not.
No. I had reviewed the first appearance paperwork and the pretrial detention minute sheet. I did the pretrial detention the day before Mr. Henderson filed his notice of appearance, so I was present for that. I don't recall Judge Stone revoking the bond. Doesn't look like it was revoked at first appearance.
All right. I signed an order granting the motions, the state's motion to revoke bond on March 5th.
Okay.
So I don't think it was done at first appearance because, frankly, I was the duty judge that was handling the warrants as they were coming in on the new case.
Okay.
And so they sent me a motion to revoke his bond, which I granted. And I don't think there's been any sort of motion to reinstate it at this point. But yeah, it wouldn't be in the first appearance paperwork because it was already done at that point.
Well, if the court grants the motion for Mr. Henderson, then the court can expect to see a motion from me right behind it. Okay.
Do y'all want to try to piggyback that tomorrow?
Not really, because the motion is at 2 o'clock. I have not talked to Mr. Henderson. I don't know if he's intending to call. I don't know why it's at 2 and not 9. So I don't have anything else on the 2 o'clock docket.
I think it's contested and they're expecting there to be significant argument. And I think there's already been a motion for judicial notice of the transcript.
Okay. I kind of figured it was more involved than a simple, 10-minute argument on a morning docket. I'll just pay attention to it. If the court grants it, I'll probably file a motion right off the bat.
All right. Mr. McQueen, we'll see you with Mr. Henderson tomorrow. This case will be 10/28 at 9 o'clock.
Mr. Rainey, Mr. Watkins.
Morning again, Your Honor. May it please the court. This is State of Florida versus Malachi Watkins, 25-2028, Russ Raymond on his behalf. We discovered in depositions there were 4 or 5 additional category A witnesses that the state was not aware of, as well as some phone call evidence that the officer said should be getting to the state. Working on getting those depositions scheduled. If we could ask to put it on the 10/28 docket, hopefully have those depots done by that date.
All right, state, anything else?
That's
No,
pretty much, oh, I'm sorry.
There's only one case, right?
I
Yes,
think
sir.
we received the additional report, I want to say Monday, and we should be sharing it with you soon. And probably we're going to share an additional witness, one of the officers who was present for the warrant, search warrant.
All right, so it's going to be October 28th at 9 o'clock. This case is getting a little bit older. I know there's new evidence coming in, but let's try to make it a priority to push this through.
Will do.
All right, thank you.
Judge, I think that's all I have before the court might be excused.
I believe that's it. Thank you, Mr. Raymond.
Thank you, sir. Good to see you.
You too. All right.
Mr. Maura Chisholm lined up for Harsher.
Mr. Harsher, covering for Mr. Crawford.
Maura Chisholm.
Morning.
Dustin Harsher, covering this case for Attorney Chris Crawford this morning, Judge. We have taken depositions in Mr. Chisholm's case. We're going to ask for one more continuance today, Your Honor. We're looking into getting Mr. Chisholm evaluated. Waiting on those transcripts from those depositions as well.
Without objection then, Your Honor.
Okay. It's going to be October 28th at 9 a.m. thank you.
I don't have anyone else lined up.
Thank you, Your Honor, that's all I have.
All right, thank you, Mr. Harsh. All right, Mr. Nopes, are you ready?
Mr. Noakes tells me he's ready. I'm gonna try and get a juvenile out of here. Which
Is he-
is- Cunningham is a juvenile that you have.
Okay.
And if Mr. Williams is ready on Carson Arnett, that would help us as well. Okay. Martin, here if I do two juveniles, not please write that down.
That's fine, absolutely.
Mr. Cunningham. Cunningham? Yes, am I stand on that for that second?
Judge, I've got Mr. Cunningham's case, 26 CF 321. Judge, we had depositions 2 weeks ago or so. The arresting officer had some additional discovery that he was putting together to send to the state. I know my office emailed the state to see if they had received it yet. I don't know that they've actually filed a discovery notification yet. They may have already done it, though, overnight. I don't know. But the case needs to be continued, and if we could approach, we'll tell you the rest of the story.
Sure.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street.
October 28th at 9 o'clock for pretrial for Mr. Cunningham. All right, all right, so I think we've resolved Mr. Cunningham. Do we want to handle Mr. Arnett? Is that what y'all said? With Mr. Williams? With Mr. Williams?
Morning, Your Honor.
Morning, Mr. Williams.
Got State of Florida versus Carson Arnett. That case number is 26 CF 320. There's a few things going on, Judge. There were some depositions taken on August, I believe, the 6th or 7th, and I'm ordering up copies of those, and I've sent an order to you so that we can get JAC to pay for those transcripts. And also, there's the state attorney's motion to transfer my client to a different location, which I don't object to. I've talked to my client about. So I would request a continuance, Your Honor, I guess till that October date.
All right, October 28th, 9 o'clock.
Thank you, Your Honor.
Thank you.
I have several others. I don't want to cut in anybody's line, though.
He's going to go back to Mr. Nopes.
Good deal. Very well, Judge.
I think they've already got them all lined up, Mr. Williams.
I need help back there? I help you out.
Kelly.
Judge, I've got Tristan Colley, 25 CF 1488. Judge, I was appointed on May 20th. I received discovery on August 21st. Judge, I'm going to ask that we leave this set for docket day in hopes that we could maybe reach an agreement and get it resolved, but it would be set clear continuance for docket day.
All right, September 1st, 9 o'clock for docket day, that's next Tuesday. Please continue.
Thank you, Judge.
All right, thank you, Mr. Knowles.
Mr. De La Rosa.
Judge, Mr. De La Rosa, we filed a motion to withdraw, and I think we're still waiting on the proposed order for a new attorney to be assigned. Done it in the last day or so.
I don't have an order.
I will ask my office. He told me that he had sent it whenever he filed the motion. He sent.
I don't see it.
Okay. But we'll send it today saying.
Just again, make sure you just email it directly to my assistant.
He does.
Okay. And I'll verify
And
if she's received it.
I'm gonna tell him to red flag it. Say, hey, it's
Yeah.
red flag it for us.
That's the way I get them done faster, because when I go into my box to sign things, I always go to that first.
All right, we'll do that.
Do we know who's going to be next on the list? Guess it's somebody who's here.
Still here?
Yeah, it's all right.
Mr. Williams.
Okay.
Charles Williams.
All right. Mr. Williams, Charles Williams. He's right behind you. He's talking. All right. Mr. Nopes is withdrawing from this case. You're next on the list. This is Mr. De La Rosa. It's a very old case. I think the issue was there was just, I don't recall off the top of my head if it was a Nelson hearing or it was just a conflict that had arisen. I think it was both at one point, but, so.
Obviously, Judge, you are.
Say again?
What surprises you are?
About what?
I'm withdrawing.
Well, he just got appointed last month and he says he's got a conflict. I don't know what the issue is. I can't delve into that because I could divulge information about other people or other clients. All right, Mr. Williams, what would you like to do? Do you want to just put it on for October? Do you want to try and talk to Mr. De La Rosa between now and next week? What would you?
No, Judge, I'm going to ask you to put one of my other cases that you're about to hear on next week on Thursday. So maybe we could do that, and between now and then I can have a conversation with Mr. De La Rosa and kind of get up to speed.
What are you putting on Thursday?
Maybe it's Wednesday.
Tuesday's docket day.
Tuesday's docket day.
That's the first, correct?
Yes.
Yeah, I'm not able to, a medical procedure.
You're fine. You don't have to get into, if you can't do it, you can't do it. Let's see, the 3rd. Well, now all the cases for the 3rd in the morning say 9 o'clock when they used to say 10 o'clock. September 3rd, we were supposed to start at 10 and everything was at 10. Now everything says 9, in my system at least. All right, we can put you on September 3rd, that's next Thursday at 10 o'clock, just for status as to what's going to happen with the
That's
case.
fine, and I'll be asking you to do the same thing on another case.
Okay. But it's just, so you know, it's 10 o'clock, we've got a out-of-town speaker speaking to the bar at 8:30 in the morning that day.
It works for me. I have another hearing at 9 that I was going to have somebody cover it. I can do by Zoom, so.
Okay. Because initially, we weren't supposed to have a docket next Thursday, but I'm trying to throw some things on there to get things moving. All right, so Mr. De La Rosa, we'll see you back next Thursday, September 3rd at 10 o'clock for status. And then Mr. Nopes, if you could just make sure to get that order to me with Mr. Williams' name on it.
Be sent as soon as I get to the office, Judge.
All right.
Judge, the next case I've got is Tyson Odom, 26 CF 718. Judge, we moved to withdraw because there was a co-defendant that I ultimately got appointed to, and so Jason Cobb, there is an order, I saw it just yesterday, I think, that he's.
A signed order?
Signed order.
I thought we had done it a while back, but then it.
Maybe so.
No,
I just saw the
here it
order.
is. I signed it on the 13th in your case, which is the 519 case. No, that's, what about the 718 case? I appointed Mr. Cobb back on July 10th, so both of Mr. Odom's cases should be with Mr. Cobb. Has anyone seen Mr. Cobb?
I have Mr. Odom, but I haven't seen it under.
Okay. All right, we'll bring him up when Mr. Cobb gets here.
I'll text Jason.
Thank you.
That's why I get paid the small bucks. Robinson, that's what I got. Judge, Mr. Robinson has 3 cases. 2 are violations of probation, 23 CF 606, 23 CF 2731, and 26 CF 990. Judge, I'd like to leave him set for docket day in hopes that we can get it resolved.
September 1st, we're going to call it plea or continue.
Judge, for the record, I was appointed on the new case July 15th, and the VOPs were June 17th.
The new law violation is just from May, so it's probably the first time it's even been up.
Yeah, it was July 15th when I got appointed. So absolutely. So we'll try to, but it's going to be plea or continuance on the first, Judge.
Yeah, that was probably his arraignment date. All right, September 1st, plea or continue. Thank you, Mr. Robinson.
Get something worked out. Judge, the next case I've got is Colby Ryan Sanders, 26 CF 380.
All right.
Judge, I communicated.
Just really quickly, Mr. Nopes and Mr. Williams, if you're listening, my assistant was able to edit those about the alternate housing on those 2 clients of yours, so you don't have to send me new ones. I'll just sign those because she was able to edit them.
Thank you.
All right, go ahead, Mr. Sanders.
Judge, I did communicate with our expert, John Sawicki, yesterday. He has indicated that there's a meeting between himself and the Okaloosa County Sheriff's Office set for sometime the week of 9/8 through 9/11. So I think we need to continue it because the purpose of the meeting is for him to meet with him and review the data related to these charges.
Okay.
I'm asked to continue it, and hopefully that'll be the last time.
Does he have any objection?
Without objection, Your Honor, he does need to review it.
All right, October 28th, 9 o'clock for pretrial conference for Mr. Sanders. Thank you.
Thank you, Judge. Judge, the last case I've got is Taquan Watson, 25 CF 987. Judge, there's a new case that is 26 CF 1505, and that case is related to this case.
It is, from what I've read.
I'm sorry?
It is, from what I've read.
So Lisa Rivers had been appointed. She filed a motion to withdraw on August 14th, which I'm assuming the court would grant. I think we need to continue the matter, and the reason being is I think we're still having issues clearing a date to take the victim's deposition.
I believe we have the date still from, we weren't able to get an earlier one before this, but we
Yeah.
still have the original October 2nd date.
October 2nd, okay. So I'm signing now, if I can get, okay, Ms. Rivers, I've got your order, I'm gonna have to assign RCC, Mr. Kleins is, I'm sure, going to, just real quick, Mr. Kleins, just because I have to do things in the proper sequence, I'm appointing you to Mr. Watson. I believe you represent one of the co-defendants, so you're gonna have to do a motion in order, and then I'll ultimately appoint Mr. Nopes for that case. But in order for everyone to have their paperwork in order, I've got to do it that way. But ultimately, you're going to be appointed to the 1505 case, Mr. Nopes. But I've just signed the order, sending it to RCC.
Which cases are we appointed to right now?
I just appointed you to 1505.
Is that the older case with Mr.
That's the
Moore?
brand-new case for
Okay,
Mr.
okay.
Watson where he's charged with tampering.
I thought Mr. Nopes was trying to get off the older case.
No.
Okay, yep, no problem, Your Honor.
So no,
We'll
we're
go ahead.
trying to get all of Mr. Watson's cases with Mr. Nopes, but I have to jump through all the proper hoops to do that.
No, I get it. We'll go ahead
Appreciate
and
you doing that, Judge.
get that
Yeah,
taken care
I
of.
just,
It makes it easier on me.
it's, we all have our jobs to do.
Absolutely.
Who am I to stand in the way of bureaucracy?
Way to put it.
All right, so what do we want to do with,
Judge, I just
both of
asked
his-
to put it over on the next pretrial.
October 28th at 9 o'clock for a pretrial on both of those cases? You said October 2nd is the deposition?
Yes, Your Honor.
All right. All right, thank you, Mr. Watson.
Judge, the last matter I've got before the court, that covers, I believe, all of my cases, but I was contacted by Adrian Middleton this morning. Got Mr. McDonald.
He called you this morning?
He tried to call me, but I couldn't take the phone call. But he then texted me. He said that they are, and I guess, Paul, I think he indicated, he communicated with you. They're waiting on a dual diagnostic evaluator to meet with Mr. McDonald this week so that can get a report prepared, and they're trying to come up with a global resolution. I guess they're probably going to ask the court.
No, it's McDonald. McDonald is represented by Middleton, who's being covered by Mr. Nopes.
But just so that he can hear what I said, Judge, he's got three case numbers, 23 CF 1644, 23 CF 0004, and 25 CF 1192. Mr. Middleton contacted me this morning via text and asked that I cover this, that he's indicated they're trying to get him evaluated by a dual diagnostic evaluator so that they could possibly get some type of downward departure or determine if mitigation should be considered in some global resolution. So he's asking to continue it.
Wasn't this discussed last time? I'm probably the only one that was part of it last time.
It was, Your Honor. I represented Mr. McDonald for quite some time. I still represent him on a misdemeanor case. So I know it was discussed last time when Mr. Middleton was advising the court he was going to have Mr. McDonald.
You know that he did call me about this. I can't remember the exact date. I'm guessing it was probably the week before last. And he said that he was still trying to get him put in for evaluation. That was what he was at that point.
But wasn't the evaluator someone from like Central Florida?
It was I remember the way he was talking, I was like, man, I wish I could get things
It
done
was
this quick.
something from
Well,
dual
how about that?
Dual diagnostics. I don't know what any of that means, Judge.
It means mental health and addiction.
Okay. But that's what he was looking for, was somebody with a specialty in that to have them come out and evaluate to see what would it.
My problem is, we talked about this 2 months ago and nothing's been done. And from what I've heard is the lawyer who's representing Mr. McDonald has reached out to get coverage this morning to tell me the same thing that I heard 2 months ago. So, Mr. McDonald, is there anything that you want to say?
Yes, sir.
And I say that because you raised your hand. I'm not asking you for anything. You just raised your hand, so I want to acknowledge you.
Yes, sir. When we was in here 2 months ago, you mentioned to him that possibly he could get another continuance today. If it was all right with me, I don't know why you would ask if it was all right with me or say that, but.
Well, frankly, every attorney should ask their client if they're okay with a continuance. In fact, I think it's part of the rule. So,
Currently, I'm in the ECLC dorm, and I'm trying to finish that program right now.
how far along are you in the process, Mr. McDonald?
I'm in my 6th phase right now.
I'm looking over at Ms. Claude because she's in the audience.
Judge, I do want to point, Ms. Claude did hand me a letter. I didn't realize that this was the defendant that the letter was for.
Okay.
And she speaks very highly of Mr. McDonald, says that he's doing very well. Of course, she's still here, so she can speak for herself, if the court would like.
I kind of would, since I still represent you.
Frankly, Mr. Note, I know you're just kind of filling in, and Mr. Kleins is trying to be a friend of the court here for a client that he's represented in the past. I don't want to keep continuing the case because I want Mr. McDonald's cases to be resolved so he knows what he's doing. He's obviously going through a program that's been very beneficial to countless numbers of people who've gone through our jail system. I just don't like continuing it for the same reason I was told it was going to be continued 2 months ago, and seemingly I don't hear any progress. Again, I'm not faulting anyone that's standing here, but I need to know what's going on with the case before I'm willing to continue it. And so I'm going to put it on Tuesday, September 1st, for Mr. Middleton to be present so he can tell me what's gone on and what needs to happen.
And, Your Honor, so Ms. Claude just handed me an update letter for Mr. McDonald's progress in the program. She was intending this letter to go to Mr. Middleton because I still represent him on the 09 misdemeanor case, or I'm sorry, the 09, the misdemeanor case. He's on September 9th, that's why I said 09.
909.
Yeah, so I'm going to take possession. I'm going to take possession of this letter, and I will send it to Mr. Middleton today or tomorrow. So he'll have it before he comes to court next Tuesday. So I would hate to give it to Mr. McDonald, something happened to it at the jail. It's a 2-paragraph letter.
Okay. Looks like there was a couple copies of it floating around, and
Judge, did you?
the tech-savvy Mr. Nopes is looking like he's going to take a picture of it and send it right to him.
I don't know if the defense wants to take this responsibility on or not, but I don't have a problem if you want to enter it into the court record and let the judge read it and put it in the file. I don't have an objection.
Could I approach and file this?
I don't think it should be filed without the actual attorney of record who's not here to do that, maybe.
Okay.
Again, I appreciate the people who are working hard to get this resolved, but I think we need to meet back up on Tuesday next week to see kind of where things are at.
Judge, if he could not make it next Tuesday, can he?
He's going to have to file a motion explaining why he can't.
I want to make sure I got that clear, so I.
He'll be back in court on Tuesday. All right, but I'll get this sent over to Mr. Are you gonna use them?
I'll just put it out there. I don't think I'm not saying I'm the most lenient on this issues, but I don't think there's many in my position who are more lenient and letting people appear by Zoom and working around things. But when cases aren't moving because it's last minute, I want to hear what's going on. Tuesday, September 1st, 9 o'clock. If you could advise Mr. Middleton.
I'm making notes on exactly what you said.
All right.
Thank you, Judge. That's all I got.
All right, thank you.
I appreciate your patience. Please have patience. I like it.
It's early enough in the day, I still have some left.
Thank you, sir.
All right, thank you. All right, Mr. Williams, are you lined up? All right.
Sure. Your Honor, first, let me...
Tuesday the 1st.
Let me call the Mr. Barr's case, and then I'd like to approach you and discuss some things with you about it.
Okay.
It's State of Florida versus Jaguar, we got three case numbers, Your Honor, 22 CF 1851, 23 CF 1016, and 24 CF 2616. And if Ms. Leone and I could approach.
850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back home bakery.
All right, so Mr. Barr, based on the things discussed up at the bench, he's going to be set for next week, Thursday, the 3rd at 10 o'clock for a Nelson inquiry.
Very well, Your Honor. And next, I would like to call State of Florida versus Timothy Cochran. That's 24 CF 2690. That's again with Ms. Leone. And Mr. Cochran is joining me here at the podium now. Your Honor, I would request a brief continuance actually until next Thursday, the 3rd. Ms. Leone and I are engaged in active negotiations in this case. I believe we will have a resolution by next Thursday. If not, then we will be prepared at that time to set it for trial.
What I'm going to do is I'm going to list it as plea trial. We'll put it on, we won't put it on the docket day because I know that there's an issue with that, the 1st, so we'll put it on the 3rd to kind of handle that same issue. If it's not resolved on that day, it would be set for trial. It would have jury review on September 11th.
And 11.
And then the trial dates would be the following Monday, so the 14th, or the Tuesday after that, which is the 22nd, because that Monday is a holiday. So basically the weeks of September 14th and 21st are the trial weeks, but Monday's a holiday on that second week.
And that 9/11, we call that jury
review.
Very well.
I know every county and every judge calls things a little bit different. We use the same terms for different things, but I think that's consistent across Okaloosa County, at least for now. All right.
All right, thank you,
Thank you,
Your
Mr.
Honor.
Williams. We'll see you all back next week, Thursday.
Next, Your Honor, I have State of Florida versus Zachary Henderson. That's 2 case numbers, Your Honor, 26 CF 184 and 26 CF 327. Your Honor, we have depositions scheduled for the 20th of October in this case. So I guess I'd request that 10/28 return date. At least we can check on the status then. We may have a resolution, or we may be, at least we can let the court know what's going on at that time.
All right. These are relatively recent cases, so I'll put it on October 28th at 9 o'clock for pretrial. Depots will be on the 20th. All right, Mr.
Thank you, Your Honor.
Henderson.
And let's see, next, the State of Florida versus Michael Livingston. 4 case numbers, Your Honor, 25 CF 2113, 2114, 2115, and also 25 CF 2437. Your Honor, this is my first time up. You recently appointed me on this. It was 4 cases. I reviewed the discovery I received. I felt like I needed an investigator. I made a motion. You granted that motion, so the investigator's just on board. And he is scheduled to meet with Mr. Livingston to go over some stuff next week at the jail. So I would request, again, that October pretrial date on the 28th.
All right, and I think I had reduced the number of potential hours for the investigator. If he burns through those and there's a need for more, because there's 4 cases, I'll certainly consider it. But I'll be honest, at a circuit judges conference I was just at 2 weeks ago, we had a discussion with JAC, gave a speech, so I'm trying to make sure I'm staying in line with what we're supposed to be doing on those things.
Yeah, I'm happy to, start with a lower number and come back if we need it.
It's my understanding they don't object, but it's ultimately for me to decide what's the right amount. And I think I have to be somewhat as a, control those purse strings to some extent.
And Your Honor, of course, I also have to certify the bill to JAC. It's submitted by my investigator to them, but then I certify that I've reviewed it and that it was all necessary work. So I understand. I'm basically in the same situation you are, so I'm fine with it.
To the extent have some sort of fiduciary relationship with the taxpayers' money for those purposes, I'm going to make sure that I'm fulfilling my duties.
Very well. Understood, Your Honor. And lastly, Your Honor, I have the State of Florida versus Trevante McLaughlin. That's 25 CF 1383. And Mr. McLaughlin has another case, and that is
26 CF 726.
and he's represented by Mr. Jay Williams in that case.
Yes.
And I believe Mr. Williams is going to join me here.
Okay.
Podium.
Judge, I've got the trafficking case, which after talking with the state, looks to be vastly improved. We still need to agree on the details, but it didn't come back as fentanyl at all. It came back as methamphetamine, so it was at least a controlled substance. But we're not looking at...
Improvement over Monday on other cases.
So in any event, I think if we leave it on for 9/2, do you think that'll be sufficient time to nail things down?
Yeah. For the first, you mean?
9/1, I'm sorry. Well, do you, my understand, I'm getting this case confused with Landon. So do you have an offer that just covers yours, or are you wanting to combine them both, Josh?
There was a global offer, so.
Yeah, it was, but it's going to be significantly reduced, but I don't know by how much at this point.
Judge, could we maybe leave it open? Would you be back by the following Friday?
That would be the September 11th date. Is that what you're talking
Well,
about?
we could do that.
We could do September 3rd, or we can do the 11th.
I don't want to load up your September 3rd docket, but I'm going to be here anyway, so.
Oh, you will
Me
be
too.
on the 3rd.
That's fine with me.
Judge, I'm going to be here every stinking day you're in court. That's the way this works. So it's not going to adversely affect me at all.
Mr. State Attorney says that's enough time for him to.
September 3rd?
Yes, yes, Your Honor.
All right, September 3rd at 10 o'clock. Remember, that's a late start.
All right, Trevante.
And
Details worked out.
I'm just trying to put things I think will be quick.
Okay.
And
It does say 10. Well, the problem is sometimes whenever your system feeds information to mine, even if you change it, it doesn't change on my side. And it's just like, once it's there, which is weird because it said 10 o'clock on Monday when we were looking at it, and now they all say 9.
I just had them change it back. I'm not sure what happened. What was the date for Livingston? I didn't hear the date.
Your
What
Honor,
did we do
that-
with Livingston?
That concludes my business.
Hold on a second. With Livingston, did we put him on 10/28?
10/28 at 9 a.m. for a
And then
pretrial.
9/3 at 10 o'clock for Mr. McLaughlin for potentially a resolution. That's both of his cases, Mr. Williams and Mr. Williams. McLaughlin's represented by the law firm of Williams and Williams.
Unrelated. Thank you, Your Honor. See you next Thursday.
All right. Good luck on Tuesday.
Thank you.
Mr. Kleins.
Yeah, just run it. Yeah, let's go. Your Honor, this is Barry Castleberry. This is his first time up. If I didn't file it yesterday, it's getting filed this morning. There's going to be a bond motion filed. It was written yesterday. I'd ask the court for continuance, but the court will see Mr. Castleberry again here at the first available court date. I can get that bond.
Don't see the motion, but it may have been filed and it's just not been processed yet if it was filed yesterday.
Right, it was written later in the day yesterday, so.
Okay. Actually, well, oh, he had filed one when he was represented.
Yes, he did, yes.
Represented at the time.
Would the court let me argue that next Tuesday? It's a 3-paragraph motion.
Does Tuesday look like at this point? Is it even updated? So you have any objection to hearing that on Tuesday?
What's the motion for? I don't show.
Set bond, it's not there yet, or reduced bond, I'm sorry.
Marshall, he currently has 3 $5,000 cash or professional bonds. We're asking to reduce 1 to $1,000 cash or professional, 2 to ROR, simply because that's all he can afford.
Let me look at it, but I mean, we might be able to do it before. Yeah, the state has no objection to arguing it on Tuesday.
All right, then we'll put that on September 1st at 9 o'clock for purposes of the bond hearing. But ultimately, you're going to want to continue the case?
Correct, yes.
Okay.
Depositions are going to need to be
Well,
taken.
I'll announce the pretrial once we decide if there's going to be a bond
Absolutely.
reduction, because that would change what his date is.
Yes, sir.
All right, we'll see you back next Tuesday, Mr. Castleberry, 9 o'clock.
All right.
Dennis?
Oh, he's here. I don't see him on the transfer list. Your Honor, this is Mr. Marcus Demmons. I looked yesterday, the court had already continued all of Mr. Demmons' cases, so I believe they've already been continued. One of them didn't look like it was, the clerks had updated it, but I looked at the order, and the order had all 4 cases on it, so.
I put him on just because he was on Monday.
Okay, no, that's,
Yeah, I don't see him on my docket.
all right.
I think he was supposed to be on Monday, then we put him on for today, and then I continued everything.
And then yesterday I looked, and I was like, well, okay.
Okay. All right, so he's 1028?
Yes, sir.
Forrest.
Your Honor, this is Kevin Forrest. We are deep into plea negotiations on Mr. Forrest's case. We could say if you want plea or trial, but I expect this is going to be a plea on Tuesday. Or I'll say plea or continue, but things are heading toward a plea.
And if it's not a plea?
We'll go to trial.
So plea trial?
Sure. I mean, is that okay with you? I don't see why it wouldn't be a plea, but if the court wants to leave it on plea or trial, that's fine.
What happened to the co-defendant's case again?
She pled to 23.75 months, and so we are trying to see if ECLC might be an issue for Mr. Forrest. So that's what Mr. Sheik is considering.
All right, September 1st, 9 o'clock, plea trial.
I'll see you on Tuesday. Okay.
Johnson?
Your Honor, Mr. Johnson is signing a plea agreement to resolve these 3 cases. At this time, today's 8/26. At this time, Mr. Johnson in 25 CF 1310, 26 CF 781, and 26 CF 799. He's going to be entering a no contest plea, except for count 1 in 26 CF 781, that is fentanyl trafficking. The FDLE came back no controlled substance on that. So he's going to be entering a plea to the remaining counts. The agreed upon disposition with the state is that Mr. Johnson will plea as charged on 25 CF 1310. He will plead to counts 2 and 3 on 26 CF 781, and plea as charged on 26 CF 799. On all of the misdemeanor counts, Mr. Johnson will be sentenced to credit for time served. That will leave 2 felony counts, burglary of a structure in the 1310 case, and introduction of contraband in the 799. Mr. Johnson will be placed on 3 years of probation concurrent for those 2 counts. He will submit to a substance abuse evaluation and any recommended follow-up treatment. In 25 CF 1310, that's the burglary case, Mr. Johnson will have no contact with Tabitha Fowler. And Madam Probation, that's Tabitha spelled Tabitt. He will also pay $138 in restitution to Ms. Fowler in the 1310 case. He would be assessed $615 court costs for each case, a total of $250 for the cost of defense. He would be adjudicated. This is his first time being adjudicated. I've explained why, and he's aware of that. He's okay with that. So if I may approach with a plea and score sheet?
Yes,
May I
sir.
approach you, Your Honor?
Sure.
Is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right. Okay. All right, Mr. Johnson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Tanner Michael Johnson, 122304.
Okay, Mr. Johnson, you're here in 3 cases, 25 CF 1310, where you're charged with burglary of a structure, third-degree felony punishable by 5 years in state prison, petty theft, second-degree misdemeanor punishable by 60 days in county jail. In 26 CF 781, you're charged with trafficking in fentanyl, which is a first-degree felony punishable by 30 years in state prison and a 7-year minimum mandatory. Count 2 is resisting without violence, and count 3 is paraphernalia. Those are both first-degree misdemeanors punished by up to a year in county jail. And then in 26 CF 799, 1 count of introduction to contraband, third-degree felony punishable by up to 5 years in state prison. Do you understand what you're currently charged with? Okay, and Mr. Tanner, I have a plea and sentencing agreement between you and the state that would have you plead as charged with the exception of the trafficking charge, which is going to be dismissed based on the state's announcement that the alleged fentanyl came back as no controlled substance. Otherwise, you'd be pleading as charged. In the felony cases, it would be 3 years of probation concurrent. You're to do a substance abuse evaluation and recommended treatment. No contact with Tabitha Fowler. $615 in court costs.
That should be times 3, Your Honor.
Well, I think it would only be
That
times
should be times
2
2.
and then 270 on the 781 case because he's only pleading to misdemeanors there, right?
Correct, and then the cost of defense would be $300.
Yes, 100, 150, and 50.
Yep, yes.
And then $138 in restitution, and is that to Ms. Fowler?
Yes, Your Honor.
Okay. And then on the misdemeanor counts, that would be 781 counts 2 and 3 would be just credit for time served.
And I believe there's a misdemeanor count 2 in the 1310 case.
Oh, yes, I did miss that, excuse me. So that would be time served as well. So basically, he's going on probation for the burglary and the introduction of contraband.
Yes, Your Honor.
Correct? All right.
Yes.
Is that the state's agreement as well?
It is, Your Honor.
Okay, I just want to make sure I've gone through that. Mr. Johnson, did you understand the sentencing and plea agreement? Did you have enough time to go over it with your lawyer, Mr. Kleins?
Yes, sir.
And did you understand and sign the actual agreement?
Yes, sir.
All right, and are you satisfied with your lawyer's assistance and representation in this case? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've just read to you? And do you understand that by entering a plea, there won't be a trial of any kind? And do you understand you're giving up your trial rights, which start on page 1 of that agreement you signed and going down to the second page?
Yes, sir.
You understand you'd be waiving those rights? And you understand you're waiving any potential defenses you have in these charges? And you understand if you're not a U.S. citizen, that you may be excluded or deported from the country based on this plea? All right, Mr. Johnson, what is your plea to the burglary, petty theft, resisting without violence, paraphernalia, and introduction of contraband?
Contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on 26 CF 781, count 1, the trafficking in fentanyl.
State will null process that charge due to no fentanyl being found, Your Honor.
Okay. All right, so as far as the felonies, so that's the burglary in the 1310 case and the contraband in the 799 case will be 3 years of probation, substance abuse evaluation, any recommended treatment. No contact with Tabitha Fowler, $138 in restitution to be paid to her. There'll be a total of $300 in cost of defense. That's $100 for each of the felony cases, $50 on the misdemeanor only case, that's $781, and then the $50 application fee. $615 court cost times 2, so that's for the 1310 case and the 799 case. Well, yeah, $615 for that, and then $270 on the 781 case, which is only misdemeanors. All right, Mr. Johnson, I think I've got that all correct. Any objections to the score sheet, Mr. Klein?
No objections, Your Honor.
Shows 26.6 points, so this is a guideline sentence. Mr. Johnson, I need you to speak to probation, who's sitting there behind you. On your way out, I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. All right, thank you.
Your Honor, this is Ms. Cassidy Lamb in 24 CF 1701. I have reached out to Mr. Campbell with the Sheriff's Office to review the download that we talked about last time. I'm waiting to hear back from him. I suspect that I'm probably going to hear back from him in the next week or so.
What was the name again of him?
Casey Campbell?
Casey Campbell.
Yes, Your Honor.
So from the Sheriff's Office.
Yes. So,
May I call Ms. Bosso, please, Your Honor? Because
yeah, I'm sorry, I didn't realize she wasn't here.
If we approach briefly, Judge?
Sure.
open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
All right, back to Ms. Lamb. It's all right.
So, Your Honor, I'm going to ask the court for a continuance because I need to review these text messages off of the co-defendant's phone. I can't do that. The state can't give us, for reasons we've already discussed, they can't give us a report.
I understand, but haven't we talked about this a couple of times now?
Exactly, Judge. The state's ready for trial. Ms. Lamb's case is not complicated.
Your Honor, I emailed Mr. Campbell on August 7th, and I have not received a response.
How about if you try again then, sir? I mean, or let me know, and then I will...
Or if witnesses don't want to respond, when they're the only ones who have access to the evidence, I'll entertain other motions then. I understand the situation, but we can't keep having the same problems. I mean, do I need to send a letter to somebody so these things can get done in a more timely fashion?
But just because someone doesn't answer one email, I mean, I always tell people, please follow up, because we don't always see everything. Everybody's perfect.
I'll certainly keep that issue in mind then. I don't disagree with Ms. Basso, but at the same time, there has to be a response, especially in an email. It's not like it was a phone call that he didn't leave a message. I want to keep it on the first, given that we may set it for trial that day, and I want an update specifically, and maybe copy Ms. Basso on your next email.
She was copied on the last one, Your Honor.
Okay.
Move on for 9-1.
I know there's an issue with the other companion case to this one, or co-defendant because of new counsel, but these cases are from July of '24.
And my intent is not to wait for the co-defendant's attorney to get up to speed.
I understand that, Mr. Klein, but you have to understand why I'm trying to push these things.
I understand.
Especially when it's the same issue that I've heard at least the last 2 times. And frankly, I would bet that, I don't want to use the wrong rank or title for Mr. Campbell, so I'll just refer him to as Mr. Campbell. I'm sure he's very busy because of the volume of cases that involve these things these days. However, there's got to be more time to become available for viewing because it's required. You have to do your due diligence, Mr. Kleins. I understand that. There's only one way to do that. It involves only one person who seemingly is able to do that from their agency, but you just need to be pushed. So we'll see you back on September 1st at 9 o'clock to find out if there's been any progress made on that issue. And see if it can't be done even before that date or shortly thereafter, and you can potentially be ready for trial or not. Just. All right, September 1st.
All right.
I called this last continuance last time, and I think I did the time before that as well. All right, thank you, Ms. Lamb. I'll see you on next Tuesday.
Oh, Ms. Powell? Okay. Your Honor, this is Ms. Brianna Powell in 26 CF 945. This is her first time up, at least with me. She is currently under an 1129 sentence. This does not expire until November. She does score in this particular case. I've talked with Mr. Mall. I'm going to ask the court to continue this. However, I expect the court to see Ms. Powell probably in the next couple of weeks. It's for entry of an early plea. But as of right now, we need to ask to continue this to the 1028 docket.
Okay, any objections to that?
No, Your Honor.
1028, 9 o'clock. Thank you.
Mr. McPherson.
Your Honor, this is Desmond McTeer approaching the podium. I have talked with Ms. Leone. We are awaiting the phone download from the alleged victim in this particular case. Additionally, we have been trying to find witnesses for Mr. McTeer. Unfortunately, I think the case has to be continued one last time. I know Mr. McTeer is not happy about that. However, on count 2 is a PBL. He's looking at a potential life sentence here. I know he wants to address the court today. So
Let's address those particular issues, and Mr. McTeer, I'll certainly hear from you. I just don't want to talk about too many different things at the same time. All right. My understanding from last time is there was some sort of FDLE report that was given over recently, right? July 30th, I think it came over in discovery from what I saw. Obviously, I can't see the report, I just see the discovery exhibit. Says there was an expert witness listed from FDLE digital evidence, and there was an FDLE report. Is that the download that you're discussing?
No. The phone download is a separate issue from the FDLE.
Whose phone is the one that's been downloaded?
Victim's phone.
Okay. Why is that taken over a year?
for the longest time, nobody knew where Miss Sword was, honestly. Like, I don't know why, I'm not going to speak for the state on why, I know we had issues trying to find her for a deposition, and then she was found, and she came in June, I think on June 8th, she testified, so we have taken her deposition, so that's done. She lied.
So if you're referring to the exhibit filed under Fifth Amended, that is the cell phone extraction.
Okay. So is there a report that's been turned over regarding that phone download?
We turned over the whole extraction.
Okay, so do you have the?
Shit, crazy.
I'll have to talk to my assistant, Your Honor. We can leave this on for 9/1 if the court wants to. I know Mr. McTeer is chomping at the bit to go to trial, so.
Ready.
But it's also true, Mr. Klein's disclosed to me a witness, defense witness.
It's true.
At least one. He said he may have additional ones, but I would like to have an opportunity to depose this witness.
Have they been turned over in a reciprocal discovery?
Yes.
Okay.
In June
Oh, I see it right here, June 16th. Well, it's one person.
Yes.
Is there more than that?
We've been trying to find more people, so.
Have you given specific names, Mr. McTeer, to your lawyer to look
Yes.
into?
Sir, I done presented a lot, sir. Videos, everything, sir. Like all this, I done studied words, sir, Your Honor. I ain't gonna lie to you, sir. I remember when I first that came in, I said I be looking at you like a god, sir. But right now, it's like I used to fear you like a god, sir. But I ain't gonna lie to you, sir. Right now, this going on back and forth. Like, sir, I got stuff that put her in impeachment. Like, it's a lie. All this is a lie, sir. I got kids, sir. I never in my life disrespect. I'm a mother. I ain't gonna lie, man. I don't do this, sir. This is what they got going on right now. So I've been sitting here going with this for too long, 15 months, sir. And all this has just been a lie. Like that, we done caught her in a variety of lies. She's probably high somewhere. I don't know. I don't care. I just got kids that I'm trying to get home to, a family that really love me. I gotta I don't know what this cause was, but it like impeachment. I looked up all kind of words, you know, like, sir, I don't.
Well, let me just explain one thing to you, Mr. McTeer.
Okay.
So I'm not trying to get in between your relationship with your lawyer, but just to give you an explanation of how things work is you give him names. He's got to investigate those to make sure that people. Mr. McTeer, just listen. I didn't interrupt you, did I?
Yes, sir.
Okay. So he's got to look into those things, investigate that, and determine whether or not they're going to be good witnesses for you. Because if he turns them over first in a reciprocal discovery and it turns out they're not good witnesses for you, now the state knows who they are, and he's not done a very good job for you. So he has to do his due diligence first, and if he can't find these people to talk to them, then that's a problem. Also, you say you're ready for trial, and I'm sure you are, but your lawyer has to be ready for trial as well, given the evidence that's being turned over to him just in the past few weeks, as well as discovering these witnesses that you're looking for. I don't mind bringing it back next week to talk about it again, but I want to make sure you understand you've got one real shot with this trial, and then I don't want this to come back on some post-conviction issue because I didn't give your attorney enough time to find the people that you're talking about.
I feel as if, sir, right now, I done read so much up on this, sir, like where I feel as if, dog, it's in God's hand now, and I know God gonna want me through this, sir, but I done presented videos, all this of this whole matter, like, that put me, like, and none of that. I got videos. I got, like, real facts. Like, I got a person, a witness that this same victim done mentioned his name is on my side right now. Like, I got stuff, like, that really just put this.
This is what we're going to do, Mr. McTeer. We're going to put it on Tuesday next week, and I want to have it revisited as to whether or not we're going to set it for trial this time around. And Mr. Kleins, make sure that you have whatever the download is and have a chance to look at that. I don't know if you need someone to do it for you. I know those downloads can be pretty voluminous.
Sure.
But I'd like to know if it's something that's going to stop us from going to trial this time around.
And so the record is clear. On Mr. McTeer's behalf, I did extend a counteroffer to the state. The current offer from the state is 20 years in prison. And I've tried to explain to Mr. McTeer, as Your Honor kind of alluded to, is like, we get pretty much one crack at this, and so we've got to be ready to go. On his behalf, yesterday, I extended an offer to the state for 18 months in the Department of Corrections, followed by 3 years of probation. So I'm doing what I can, you know.
I would also ask, Your Honor, that if we go forward with trial, I'm fine as long as he's not allowed to bring the witness that I haven't had the chance to depose.
We'll talk about that certainly on Tuesday. If the person's been, reciprocal, then obviously they can bring them. If they're not, we'll talk about it. But again, typically defense lawyers don't put witnesses on a witness list until they know they're a good witness for them. There's different obligations between the state and the defense as to who has to provide everything versus who needs to provide only what they want to use. All right. We'll see you next Tuesday, Mr. McTeer.
Sir, thank you.
All right, well, thank you.
More Alvarez.
With who? With Mr. Kleins? Okay. Sorry, we have an interpreter, and I want to make sure that we can get that case.
Yes, Your Honor, that's with me. Oh, I was like, I don't have an interpreter. Okay.
Oh, with Mr. Maddox?
Yes, Your Honor.
All right. Can we potentially get that one called up soon? You're working on it? Okay.
It's close.
Okay, well, we can,
Avengers came in, they may have been on that man.
okay. Who is it?
Mr. Fajardo Castellanos, Your Honor.
Okay, all right. Go ahead, Mr. Kleins. You're here with Mr. Moore Alvarez.
Your Honor, so this is Mr. Moore Alvarez. He is the co-defendant with Taquan Watson. That deposition to take the alleged victim's deposition is scheduled for October 2nd. So I would ask the court to continue this to the 28th. I would anticipate, once that deposition is taken, the case should be ready for disposition.
Okay. All right, October 28th at 9 o'clock. If there is a sooner disposition to be had, we can certainly move it up.
Your Honor, this is Mr. Morrow. I don't think that I have to do any depositions. I did get some deposition transcripts. I talked to Ms. Rivers. She's sending me 2 more that she took last September. I would ask the court to continue this to the 10/28 docket. And the court and the state can expect to see at least one motion on a docket before the 10/28 docket.
What type of motion?
There's going to be certainly probably a motion for objective entrapment on one of the cases. This is I've never really dealt with a case where there's a VOP that gets transferred over here, and there's.
I mean, at this point, why shouldn't I transfer them back over to Santa Rosa County and have them resolved there?
Heckle, Your Honor. We did it for judicial economy, so.
This is not very economical.
Are all the cases from Santa Rosa? No, it's just the VOP, right?
Just the VOP.
That's what I thought, yeah.
Just brought it in together so that we could give him a package deal.
I've never seen that either. But Is that the 212674 or 2998? Say again?
I think it's the 22. I believe it's the highest case. So it's the Little Lascivious Battery.
I think that's the 2998. All right, I'll look into that, but 1028 for the cases until then, but get your motions filed, Mr. Kleins.
Yes, sir.
And just, I'm aware of the entrapment arguments on these types of cases, but just make sure you supply me with anything in advance so I can read if there's any other case law or anything that's, in fact, I think I just read one that's pretty similar the other day. But I just want to make sure I'm reading everything that you may have that might be different from other cases I've recently seen.
Yes, sir.
Because frankly, I don't remember the facts of Mr. Morrow's case at this point. I don't want to kind of lump them all together, but I've got a couple of them going right now, so. All right, 1028.
Oh, hey, I'll see you next week. I gotta get you that copy of that stuff. Okay? All right. Your Honor, this is Mr. James Phelan. We attempted to take the depositions of the FDLE agents in 24 CF 2472. One of them showed up, two of them didn't. They did contact my office and said we couldn't do it, so we had to reschedule them. They are rescheduled for October 14th. However, I would like to leave Mr. Phelan on for 9/1. I have proposed a resolution to at least hopefully close some of these cases for Mr. Phelan, hopefully next week. So if we could bring him back for 9/1, just to see if we can hopefully get that done. But the depositions in 24 CF 2472 are set to take place on October 14th.
All right, State, any issues?
No issues from the state, Your Honor.
All right. September 1st at 9 o'clock. Let's see what you've got resolved then.
All right, I'll see you on Tuesday. Your Honor, next on the docket, I have Jared Riley. We had filed a waiver of appearance. We were not appointed on Mr. Riley's case until August 5th. I did meet with him on Tuesday. This is why I filed the waivers. He asked me to file the waiver.
He's been released?
I asked him to take him off the transport list because we filed the waiver.
Oh, okay.
But I did meet with him. I didn't file it just because. He asked me specifically, can you please file the waiver? In talking with him, my understanding is in 25 CF 1707, I don't know if any depositions have been done. We'll certainly get started on that as quickly as we can. What's that?
Just give us some dates.
Okay, yeah.
All right, 1028. 9 o'clock.
Yes.
Raul?
I don't know where they dropped yours, but I've got the heart of here now.
Okay.
That's Casey just emailed.
I saw.
Tomorrow.
Just before we handle this case, if we could, for the lawyers who have cases left, if you want to find out who's you may have here in the audience for any reason, if we want to take care of them before lunch break, I'm certainly willing to do that. I don't know who's here and for what case, so.
No, Ms. Rivers has a couple, Your Honor.
Okay, let's try and do that before we take a lunch. It's only 11:22, but obviously it might take some time to figure that out, and
Yes, sir, Your Honor.
I don't want to keep everyone here all day. All right.
Good morning. Your Honor, this is Mr. Fajardo Castellanos before the court in 26 CF 968. Your Honor, it's your first time up. I'm asking for a continuance. Could we put it on 9/1 though for possible resolution? State's going to try and get a hold of the victim. I've spoken to the victim myself, so we may be able to work something out. Unfortunately, the alleged victim in the case hasn't yet reached out to the state attorney's office, but I think we could get something done on 9/1 if that's able to happen.
All right. September 1st, 9 o'clock?
Yes, Your Honor.
Okay. Can you be back on that day?
Yes, you are.
Okay. Steve, can we potentially get him transported, ask the jail to bring him over in one of the first vans? Mr. Fajardo? Oh. Hold on. No, you're fine. There may be a change.
Apologies, Your Honor. Madam Interpreter remembered that she is unfortunately unavailable on September the 1st. What I'd ask for is a full cycle continuance out to the October pretrial conference. If I get it resolved, we'll put it on an earlier docket, Your Honor.
If you can get it resolved, just work with the interpreter's office, or we can even use language line if it involves, the case being resolved. But I'll put it on October 28th at 9 o'clock.
Thank you, Your Honor.
All right.
I'm sorry,
October 28th. Sorry, they were going to put them on next week. And the interpreter's going to come, I was going to bring them up in the first van, so that way we can get the interpreter out of here as well.
Once we started clearing out, I saw her say.
Yeah.
Put it early on the, come on, forward.
You have one more case for later?
Yeah, they're not here, I don't believe, so.
Nyquan back
Sure of that.
I can come back.
Nyquan back.
Want to do it in the afternoon?
Back at 1 if it's okay.
That'll work.
We don't have number 2 Make sure that, if they're here.
Okay. No?
Who is that we're looking for?
Is Rodolfo Sanabria. Go. You want to make me try? Nobody else wants to try? Go with Lucia.
Oh, okay. Well, you said 83, and it's 87 on my docket, so.
I'm sorry, yeah, the transport list is.
No worries. All right, well, have you heard if he's here?
He is not here.
Okay, so we'll bring him back.
Okay, I'll be back at 1.
Sorry for the delay.
No worries. Thank you so much.
I would just, and next time, just tell Deputy Williams who your people are, and we'll get them over here early, so you're not waiting so long.
I was aware of only one case today. That's why I only.
Okay.
The other one.
All right.
Thank you.
Thank you.
Thanks, Heidi.
All right, are you jumping in?
Your Honor, we have some out of custody. I'd asked if I could.
Okay. I was gonna let Mr. Kleins finish his, but if.
Sorry, I thought Mr.
I just want, because so they can get people off property and new people brought onto property and. But if you could bring those up once we finish up with Mr. Kleins, then we'll go from there.
Your Honor, this is Mr. Brandon Rowell in 26 CF 1045. He has picked up a new case in 26 CF 1598 when he was arrested and went through first appearance on the 1598 case. His bond in the 1045 case was revoked. That 1598 case is a one-count driving on a suspended license. Mr. Rowell was allegedly driving an ATV somewhere near Holt and got arrested for not having a driver's license. I was going to ask, I met with Mr. Rowell yesterday at the jail. I met with him actually at my office about 2 weeks ago. We're going to have to continue the 1045 case. However, Mr. Rowell was wanting me to file a motion to reinstate his bond on the 1045 case. I don't know if the court would let me do that on Tuesday or next Thursday. The motion has not been filed yet, but it can be filed today.
Is it a new law violation?
It's a new law violation. It's 1598. What you're seeing there.
State have any objection to hearing that on Tuesday?
No objection, Your Honor.
I'll hear it on Tuesday, but
I'll get it filed.
it's a new law violation while on bond. He's
Understood.
pretty significant history, including failures to appear, so. And from my reading of the report for the new case, he's been suspended since 2008 with a recent DUI in ~23. 9-1 for purpose of that bond hearing. I'll just be honest, Mr. Kleins, I'm probably going to hold those bond hearings so close to the end.
That's fine. I understand.
It's a
Yes,
docket day, not a miscellaneous.
Sure, and I do appreciate the court kind of working on me a little bit, so I'll wait till the end on that one for sure.
All right, thank you, Mr. Brown.
Mr. Sledge.
Your Honor, so this is Mr. Sledge in 24 CF 2745. I did meet with Mr. Sledge on Monday afternoon. Officer Horder was present to witness that meeting. He wasn't in the room, but he was watching. I explained to Mr. Sledge we have taken 2 depositions in the case. We did depose the main investigator and one other, I believe it was an officer. The alleged victim was not present. She wasn't found. The independent witness was not found. In reviewing the discovery, I don't see that the state has listed any medical personnel that they intend on calling in case the alleged victim doesn't want to testify. Mr. Sledge wants me to say ready for trial. I don't personally think the case is ready for trial. I can get it ready. However, there are multiple FDLE experts from around the state who have their fingers in this case. There were reports out of labs in Tampa and Pensacola. So if he wants me to say that he's ready, the case is ready for trial, I don't think the case is ready for trial, but if he wants it to be, I can get it to be. But I'll defer to Mr. Sheik. He's the one with the burden here and the witness issues.
Mr. Sheik, are you ready for trial?
State is ready for trial.
Okay. Mr. Sledge, I can talk to you about these things more thoroughly at a different date. I just have a lot of people here for today, but your attorney's telling me that he hasn't had a chance to speak with some of the witnesses that would be testifying in your trial. And are you wanting to waive him doing any further work on that before trial? That's not an answer.
That's y'all job, I thought. I mean, you put me in jail, you said you got all this evidence. I mean, that's your job. That ain't my job. My job is I'm defending myself. I'm ready for trial. I mean, y'all have to get that together, not me. I thought, I mean, that's something that's supposed to go on, so you supposed to have that. I mean, 18 months, 2 years in jail, you should already have that. I mean, what they pay you for. I mean, you put me in jail, you said you already had it, so you should already have it.
All right, hold on just a second. Whose phone was that? Turn it off. Ma'am, you're clearly streaming this court date. It's not funny. Turn it off. Off. Mr. Sledge, I don't know how to unpack all that. It's not the court's job to gather evidence. It's the prosecutor and law enforcement's job to gather evidence. My question to you is, some of those people have not been talked to by your lawyer yet because they either can't be found or they didn't show up for a deposition that was set for what, last week?
I think it was a week before last.
Okay.
It was the last 2 weeks.
Okay. So what I'm asking you is, the state has its evidence. Would you like your lawyer to continue to look into that evidence and depose some of the people he hasn't had a chance to talk to yet before you announce ready for trial? Otherwise, do you want to basically say you're okay with your lawyer not doing those things and come back and set the case for trial now?
What have y'all been doing all these months I've been in jail?
Again, you're not answering my question. What's been going on for all these months, Mr. Sledge, is...
jail, you said you had evidence, so, I mean, I'm just saying, them people should be here already. That's your job, that's not my job.
It is not the court's job to present evidence.
But whose job is it then? I mean.
I think I just explained to you, Mr. Sledge, that law enforcement gathers evidence and they provide it to the prosecution, who then has the burden to prove the case at the trial. Hold on. I haven't interrupted you, Mr. Sledge. You interrupt me all the time. We're not going to do that today.
I'm sorry.
Okay. Your defense lawyer's job is to review that evidence, strategize with you, and present your defense at the trial. Whether that means providing your own evidence to the jury or simply combating the evidence that gets put on by the state. As you know, you have a right to remain silent. You have no burden in the case. You don't have to prove anything. The state has to prove you've done what they've alleged. The court doesn't provide evidence. I'm here as the judge to determine what evidence is admissible and go through the court procedure of what a trial is, picking the jury, handling objections, and making sure a procedure is taken care of. I don't provide any evidence for one side or the other. I want to make sure you understand that, because part of the reason that's delayed this case is concerns about whether or not you were competent to proceed based on some of your behaviors in court as well as outside of court. That situation's been resolved, right? Okay. Once you met with the doctor, she gave us a report. The court's found you're competent to proceed. So that's why your lawyer is proceeding with his diligence and finding out what the evidence is and preparing for the trial. But what you're saying is you don't want him to do that anymore. You want to set it for trial. And I want to make sure that's what you really mean.
I've been saying I'm ready for trial since I came to jail.
Okay, well, I understand that. And I somewhat explained this to someone earlier, which obviously you didn't hear it because you're not in the courtroom. But it's not just about, are you ready for trial? Is your attorney ready for trial to defend you? Because frankly, when you're the defendant, you're there helping your lawyer, but the lawyer's doing the vast majority of the work, right? So I want to make sure he's ready. Based on what he's told me, he hasn't had a chance to kind of test this evidence as far as subject it to some sort of questioning of his own through depositions. And he'd like more time to do that. But what I'm asking you is if ultimately you want to go you're ready for trial and want to go, despite the fact that your attorney has announced he hasn't had the opportunity to do that.
Is it okay if I could speak now?
Yeah, I finished
okay,
speaking.
So understand me, okay, my lawyer, okay, for instance, we done been over, I want to fire him, I want him gone. He said he want to be here. He said he need time to do these type of things. Okay, the state said they had these people. Okay, y'all set up depositions for these people to show up to these type of things. Mm-hmm. So these people have a right to be there. These people supposed to be there. Not based on me. Listen to
what people?
Like okay, the doctors and stuff, the reports and stuff. Because okay, like for instance, I'm charged with something, but okay, the alleged victim was shot in the leg, but I'm still charged with murder.
No, you're not. We've discussed this numerous times, Mr. Sledge.
With attempted murder, okay, but below the waist, if you do the law, below the waist is aggravated battery. But guess what? I ain't complaining. I'm just ready to defend myself.
I don't know what you're referring to as the law.
I'm just the law states in different things, but I'm just saying these people should be ready. I'm not saying you, but the state attorney saying that they got this evidence.
They're saying they're ready for trial.
Okay, well, then they need then them people should have been there already. Okay, and my lawyer, what has he been doing? I mean, in general, when these things should be, he should have been going over all these things. Cause I mean, I'm in jail. He's representing me. I mean, I no disrespect to nobody. Listen to what I'm saying. I have a right to defend myself.
Of course.
And all I'm saying is this stuff should have been done. He said he wanted me to be talked to by the psych people because he needed time to do the case and he couldn't do it because he said the way I was acting. Okay, he said it for the record. But okay, now what have you been doing for 7-8 months? It's been a whole year.
Would you like me to respond, Mr. Sledge?
Yes, please.
Typically, when there's a pending concern about competency, the lawyer doesn't do significant work to pursue the case in the defense because he wants to make sure he has a client who's able to work with him. And if you're not competent to proceed at that time, or there's a question of that competency, then there's a concern that you weren't able to help him prepare. part of the issues that the doctors look at and ultimately the court makes the decision on determining competency is, are you able to help your lawyer prepare your defense? So while that's pending, the lawyers typically don't take depositions and things. Now that you finally met with a doctor after we had to order you to do that numerous times, that doctor has given us that opinion. I've made a ruling based on that opinion. Now he's pursuing your defense. And frankly, Mr. Sledge, if you had seen the doctor the first time I ordered it, we'd be 6 months farther down the line already. Or the discussion we're having now would have been 6 months ago.
I done been to prison. You ain't deemed me crazy when you sent. I done been sent to prison a bunch of times. I ain't never seen the psych doctor then. I'm just saying.
And I understand that.
Every time I come, all I did was ask for. This man didn't even know me. It is his first time seeing me in court. So what did he need to deem me to see somebody psych for? He didn't even know me.
Because in practicing for as long as Mr. Kleins has, he was concerned that you weren't competent.
I give you that.
And one of the things that was looked at and actually discussed in the report is your behavior in court, which showed concerns as to whether or not you were competent to proceed. Another thing that the court has to look at in determining that is, are you able to manifest or display appropriate courtroom behavior? I think it's clear that the record would show that there's been several times where you haven't, Mr. Sledge. So that had to be determined. It's now been determined. Now the case can proceed.
Okay, so what is, Mr. Klein, what do you need to go over? I mean.
Well, number one, if you made the comment you want to represent yourself, if you want to have a Feretta hearing, have at it. I mean, I've never said I want to stay on your case. Like, don't try to represent yourself. I mean, if you
I
want.
think we've had a Feretta hearing before, have we not? And I found that you were not competent to represent yourself. You're competent to proceed to trial.
I asked you for a different attorney. You told me no. I had filed for something else, but yeah.
If you want to file something.
No. He all right. He all right. I just want to know, what do he need to go over? I mean, he's saying he's not ready. The state said they ready, but I just want to know, what do he need?
Well, then let me just make sure before we proceed any further. Are you asking to represent yourself?
Never did ask that.
Okay. Are you asking for Mr. Kleins to be removed from your case?
Right now. I mean, he's been here this long.
Well, I understand. I'm just making sure that you're clear on that, and I'm clear as to your intention as to whether or not you want a different lawyer or you want to go forward with Mr. Kleins, and I'll have that hearing if you want to make some sort of change.
I mean, I wrote the paper, you didn't dismiss him then. I think he's pretty much, I mean, for the record, I mean, you denied my motion, so this is why I'm saying it. I'm not, because, you know, those are issues I might need to raise for the lower tribunal and, you know, for the lower court, Supreme Court. Those are issues I might need to use my next time if something come up, because you already denied him me relieving.
Do we have a Nelson inquiry and an order?
I think we have.
That was a long time ago. We passed that. You said you wasn't gonna relieve him. So what I'm just saying is, I just want to know, what do he need to be done? He's sitting here.
Well, let me explain something to you, Mr. Sledge. Even if I had denied it in the past, if you have concerns about Mr. Kleins being ineffective in some way since then, or that he hasn't done something you've asked him to do since then, you can certainly bring that up by filing something, asking for a Nelson hearing. And I'll certainly do that again if there's something new.
Could I ask, what was the determination of the FDLE had sent a report back a year ago, and I'm just wondering why.
I want to make sure you understand, Mr. Sledge. I don't have access to evidence.
No, I'm asking the state. I mean, the state don't never say
Well, you
nothing.
can ask your attorney, and he can tell you, but the state's not going to communicate with you. They can't, because you're represented.
But can you ask the state?
I'll tell you, so we have FDLE reports on ballistics, on blood testing, on a number of things. So at minimum, I would like to depose these FDLE experts to find out, is this going to be a problem for you on the witness stand?
They came back negative though, right?
Well, frankly, I've never seen a blood test before. I mean, one of these FDLE reports is talking about a test I've never seen.
But I'm saying the ballistics.
The ballistics came back negative as far as I can tell.
Okay, well, my clothes were tested. What did they come back to?
I have to ask the FDLE agents.
And the FDLE wrote the report as a what, an assault or attempt to murder?
Mr. Sledge, can I just make a suggestion for you?
I just wanted to get it for the record. It's all right, thank you.
Well, it's not about being on the record. What I don't want you to do is have this discussion with your lawyer where everyone's listening to you, because your conversations with your, hold on, you always want to talk while I'm talking. I just want to make sure I get this out, Mr. Sledge. Is that your conversations with your lawyer are privileged, which means no one can force your lawyer to tell the court or the state or anyone else what you tell him. But if you do it in front of all these people, and it gets recorded on the record, then it's no longer privileged. I don't want you to put your lawyer in a position where he may say something, even accidentally, that may be detrimental to your case, or to discuss your strategies that the state doesn't get to know about and the court doesn't get to know about because you're talking about it in front of all these people. And that's the only reason I'm trying to stop you. Y'all can have that conversation in the back, bring your case back up, I'm fine to do that. I just don't want you to do anything that's going to hurt your case because you're talking about it in an open forum. Go ahead.
No, because in the court of law, in the real world, everything you say is refuted. That means if I say something, it's for the record. That way, if I appeal something and they're going to say, well, did you say that for the microphone? And then I can say, yes, I did, and they can go see it. But if I don't, then how can I refute that for the record? That's how you fight your case. So that's why I speak to the microphone, because, and you probably understand that, because I'm quite sure your wife is a defense attorney, so you know if I speak, and if they speak, it's for the record. So if I file it and I say that this was said, you know pretty much what's going to happen. But I thank you, though. I ain't trying to disrespect nobody. I just do what the law say.
And I don't feel disrespected. I'm not sure why you're bringing my wife into this, because she does defense work. But I can also tell you, Mr. Sledge, for the 15 years before I took the bench, I was a criminal defense lawyer. I know how it works. Thank you.
I see your strategy. That's why I speak to the microphone.
Okay. I don't have a strategy. I'm just making sure that you aren't divulging yours.
Give him what he need. I'm ready for trial.
Okay.
Whatever my lawyer asks you for it.
Your Honor, I just asked Mr. Sledge if we could continue this one cycle. I will try to see if I can get everybody to pose. I've already notified Mr. Sheik, and I was looking this morning. The state has not filed any amended discovery listing any medical personnel involved in the treatment of the alleged victim here. I think they're going to be necessary. I will move this case as quick as I possibly can, but I'd ask the court to continue this to 10/28. I will try to set it for trial on 10/28. I mean, Mr. Sledge is looking at a potential life sentence here. This is a 10/20 life type of situation.
Mr. Sledge, anything else you want to say based on that? Did you hear my question, sir?
Oh.
I asked Mr. Sledge, is there anything else you want to say based on that?
Yeah, I'm just ready. He said he need to continue. That's on y'all.
Okay. Well, I'm going to say this to make sure it's clear to everyone. I'm going to continue the case so Mr. Kleins can finish his work. I will not continue the case again short of something new that I haven't heard up to this point. So I would expect your trial to be no later than November of this year, Mr. Sledge. Trust me, you're one of my oldest cases. I'd like it to be resolved as well. 10/28, 9 o'clock, last continuance.
Yeah, this is Jason Walterman, 24 CF 1518. I do have the discovery. I do have the FDLE report. Mr. Walterman has a credit for time served offer. He is not electing to take that. So we can leave this set for trial.
All right.
He's
And just, Your Honor, so the court's aware, Mr. Walterman is proposing a plea to the misdemeanor counts 2 and 3 if the state were to dismiss count 1. I'll talk to Mr. Mall about that, but we can leave this on to Tuesday.
All right, I'm putting on for plea or trial on November in my head, September 1st, that's next Tuesday. Mr. Walterman will see you back on that date and see if they can get it resolved. Otherwise, we'll be set for trial later in September.
And Your Honor, I do have the 2 individuals from Monday in the gallery, Johnny Lee. Your Honor, Mr. Lee is present and approaching. He has 26 CF 303. This is an elderly neglect case. His case was on Monday's docket, the 24th. He reached out to my office yesterday, advised he wasn't aware of his court date, and is present today, so he would ask the court to withdraw the capias and put this on the 1026 docket.
Can you give me the case number again?
26 CF 303.
Where are y'all at with the case as far as a potential resolution?
I was just appointed sometime right after July 30th. I want to say it was 2 weeks into August.
Oh, I do see that now. I think part of the delay in the past was the alleged victim couldn't be found, and it turns out that she was in jail.
I think that's why that was on the July 30th docket, was to figure out, do we know where the victim is? So.
All right, I'll withdraw the capias. Mr. Lee, I'm going to give you your new court date. I want to make sure you write it down and are going to be here October 26th at 9 o'clock.
Yes, sir.
I'm making a note in my file. If you're not here that day, I'm not going to consider withdrawing the capias unless there's some sort of emergency medical situation or something along that line. So make sure you're here. What's your court date?
October 26th.
At 9 a.m. We'll see you then. Capias is withdrawn.
And Your Honor, that's it. All right, call my office, make an appointment before October 26th. And I have David Prue. Mr. Prue is present and approaching. Similar situation with Mr. Lee.
Can you give me that case number as well?
Yes,
It's
Your
on my
Honor.
docket, so I don't see it.
26 CF 1042.
Is there some reason why you weren't here on Monday?
I had last-minute transportation issues.
Okay.
Contacted PD's office.
Well, you're not represented by the PD, you're represented by Regional Office of Conflict Counsel. Well, I would have told you that when you were here for your arraignment date back on July 30th. So do you have his contact information now?
Yes, sir. Yes, sir.
Okay. I'm going to put you on October 26th at 9 o'clock. Hold on. Make an appointment with him before that date so he can work on your case. Thank you. Capias withdrawn.
I think that's all I have, Your Honor.
All right, Mr. Powell, let's take care of, well, do y'all have who you've got or out of custody? Let's take them quickly then.
Your Honor, Kathleen Shaw. She was here on Monday as well because, but for whatever reason, they had her listed for today. She's here on 26 CF 878, page 63. She is a new case. I have met with her once. We will need to get together again to go over discovery, and I am going to be setting depositions in this matter. Request continuance to the October court date.
October 26th at 1 PM.
Thank you, Your Honor. Your Honor, the next one that I have, who's also out of custody, is Laredo Yardley, 26 CF 560, 26 CF 739. We reached an agreement in this matter. May I approach?
Yes, thank you. Oh, maybe I want to keep that one. So the other case was transferred up from Fort Walton, is that?
Yes,
I'm
Your
seeing
Honor.
that? Okay. All right, Mr. Yardley, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your full name and date of birth, please?
Rado Yardley, 08/31/2001.
All right, and Mr. Yardley, you're here in 26 CF 560, grand theft, third-degree felony, 5 years maximum, and 26 CF 739, grand theft, third-degree felony, 5-year maximum. Do you understand that?
Yes.
I have a plea and sentencing agreement between you and the state that would call for you to plea as charged. In return, it'd be 2 years of probation in each case to run concurrently, waive costs of supervision, $515 court costs on each case, $100 cost of prosecution each case, $100 PD fee on each case, excuse me, $50 application fee on 26 CF 560. As condition of your probation, specific conditions or special conditions will be no trespassing at the Lowe's on Beale Parkway in Fort Walton, $1,328.99 in restitution to that Lowe's in the 739 case. Also, no trespassing at the Burlington Coat Factory located on Ferdinand Boulevard in Crestview, Florida. Do not possess or consume any alcohol. Do not possess or consume any drugs unless you have a valid prescription. Complete an anti-theft course. Complete a substance abuse evaluation and any recommended treatment. This calls for a withhold of adjudication, so it would not be a conviction for purposes of our criminal court. All right, do you understand that, Mr. Yardley?
Yes, sir.
All right. Is that what you want to do here today?
Yes.
Is that the state's agreement?
Yes, Your Honor.
All right, have you had enough time to go over this plea and sentencing agreement with your lawyer, Mr. Yardley?
Yes, I have.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's representation and counsel in this case?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement that I just read to you?
No.
Do you understand by entering a plea there won't be a trial of any kind?
Yes.
And do you understand that you'll be giving up your trial rights, which are listed on page 2 of the agreement that you've stated that you understood and signed?
Yes.
And do you understand you'll be waiving any potential defenses?
Yes.
And do you understand if you're not a U.S. citizen, that this could lead to your deportation or exclusion from the country?
Yes.
And do you understand that even with a withhold of adjudication, that could be the case?
Yes.
All right. Based on that, what is your plea to the 2 counts of grand theft?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. In each case, it'll be 2 years of probation, withhold of adjudication. Those are to run concurrently. Waive cost of supervision, $515 court cost per case, $100 cost of prosecution per case, $100 PD fee per case, $50 application fee in the 560. No trespassing at Lowe's on Beale Parkway in Fort Walton Beach, $1,328.99 in restitution to Lowe's in the 739 case. Also, no trespassing at Burlington Coat Factory on Ferdinand Boulevard in Crestview. Do not possess or consume any alcohol. Do not possess or consume any drugs unless you have a valid prescription. You're going to complete an anti-theft course. You're also to complete a substance abuse evaluation and any recommended counseling. Mr. Yardley, I do need you to be, to talk to probation, who's sitting there behind you. I believe these are theft cases, even with withhold. I do still need your fingerprints, Mr. Yardley, so I'm going to have you do that as well before you leave. You want him to do that first, Steve? Fingerprints first, then talk to probation. You have 30 days to appeal. Any objections to the score sheet, Ms. Rivers?
No, Your Honor.
All right, this is a guideline sentence as he scored 16.40 points. Again, you've got 30 days to appeal, sir. Next case.
Judge, I can call a couple. Amy
Okay.
Lamb.
Amy Lamb.
Judge, Ms. Lamb was scheduled for court on Monday and missed court. She contacted our office and we told her to be here bright and early this morning. She was.
All right, can you give me Ms. Lamb's case number?
Judge, I can look it up.
I can do that.
Here we go.
26 CF 429. All right, is there a
Yes,
reason
sir.
why you weren't here on Monday?
I honestly thought it was yesterday.
Say again?
I honestly thought it was yesterday.
Okay, did you show up yesterday and talk to anybody while you were here?
I called my public defender's office yesterday, and they told me to come in today.
All right, Ms. Lamb, what do you want to do with the case?
Judge, I don't have her file or any of my notes on it. I don't think it's that old. I just moved it.
Okay. All right, October 26th at 1 PM. Make an appointment with Mr. Williams in the meantime.
Sir.
It looks like you may have a failure to appear in the past. If you fail to appear for another court date, I won't be willing to withdraw your capias, which I'll do so at this time.
Yes, sir. Thank you.
What's your court date?
October 26th.
At?
1 o'clock.
There you go.
Thank you.
Okay. Thank you, Ms. Lamb. We'll see you then.
Thank you
Stay in
so
touch with Mr. Williams.
Thank you, Judge. And just so the court will know, Deanna Lamb contacted us also, and I think she was already set for 9/1.
Okay.
Maybe it wasn't Ms. Lamb, it was the other page will appear on.
I don't remember which person it was. I had, I
You
believe,
set 'em for
248
9/1.
cases on the docket on Monday. I don't remember them all independently. I do remember that number, though. All right, Mr. Powell, I guess they're setting you up.
Morning, Judge. Becker?
Joe Powell on behalf of Timothy Thacker, he's present. Couple of cases on the docket. We're completing discovery, asking for the October pretrial. We've got depositions, close to having them set.
Depositions in which case?
We're trying to get them all on one day, but there's two prosecutors, so we haven't completely finalized it yet, but we should have them done before the October pretrial.
These cases are from November and December of last year.
But we did come on significantly later.
Oh, I understand. I'm pointing it out there, I say this probably every pretrial now. When you agree to take on a case as a private lawyer, you make that decision to take that case where it's at. If you get appointed to it, it's different. So I'll give you one last continuance to set your depositions, but if those are not set, it will not be continued again. All right. 10:28 at 9 o'clock for pretrial conference. All right.
Powell for the record on behalf of Peyton Pierce. Mr. Pierce is present, asking to leave this on for docket day. We anticipate a resolution.
All right, we'll put it on September 1st, that's Tuesday, Mr. Powell. It's usually Monday, it's Tuesday this time, for a plea. September 1st, 9 o'clock.
Mr. Valentine. Stand on for that second.
Bo Powell on behalf of Jeffrey Valentine, he's present, asking for a final continuance. The state's not objecting. We are very close to a resolution. There's an issue out of Colorado we're trying to clear up before we resolve it.
State?
I don't have an objection to it at this point, but can't get it resolved next time, I probably will.
All right, 10/28, 9 o'clock. Let's get that, whatever that issue is, resolved and resolve it next time. All right. Thank you, Mr. Valentine.
Thank you, Judge. That's all I have this morning.
Y'all have someone else y'all want to call? Thank you, Mr. Powell.
Thank you, Judge.
Have a good day. Is there anyone else that y'all need to call? Mr. Russell, do you have something, so you don't have to come back in the afternoon, Mr. Russell?
Yes, sir, if I could.
Sure.
Charles Russell, Public Defender's Office. Judge, I represent Joseph Carroll, 24 CF 2383, and then Mr. Maddox has his other case, 26 CF 570.
Yes, Your Honor.
Mr. Carroll, both of us have met with Mr. Carroll. He waived his appearance for today's court, talked to him about what was going on. On my case, we had set the deposition of the FDLE tech, but it's set for September 11th. It's number 97 on my docket.
I'm getting there. It's just.
Okay.
Sorry, Ms. Rover's had a lot of cases. There you go. All right, that's set for the 11th.
Yes, sir, but it turns out that that's our jury review date, so we're going to have to reschedule.
What time is it set for?
9 o'clock.
Well, where is it set?
At my office.
Okay. Well, I'll probably have a lot of cases that day if you guys want to do the deposition and then come over for your cases later. I just got to know this was the last thing y'all are waiting to get done for that case.
Unless, Judge, on the 26th case, it's a similar charge. I don't know if the state's made a decision yet about Williams ruling that case into my case, so that could potentially be an issue.
State?
I don't plan on doing that, Your Honor.
Okay.
All right, so do you think this case could be ready for trial if you can get that deposition done that day?
My only concern would be, Judge, if I decide to subpoena that witness for trial and I don't know what that witness is going to say yet, I don't know that I'll have time to issue a subpoena for trial.
It would be late if we have to subpoena people after
Right,
jury review.
right.
The deposit will be late.
Last continuance from Mr. Carroll. But I would like for that deposition to be done that day. I don't have any issue with y'all showing up 30 minutes later, an hour later, whatever it is for jury review. We'll just handle everyone else's cases first.
Thank you.
Thank you, Judge.
All right.
We'll keep it then.
All right, thank you.
Judge, I just asked for the same date on mine.
That's fine, we'll put it, you want the new pretrial for, that's the 26 case?
Yes, sir, Your Honor.
Sure, and that'll be October 28th at 9 o'clock for both. All right. Anything else you want to call of people who, Mr. Cobb? Thank you for joining us.
Nothing at this time, Your Honor.
James Cardell.
This is James Cardell, Judge. I represent him. Mr. Notes covered for me on Monday, and his cases were continued to the October pretrial date. I know he's picked up 2 new charges, but the last time I checked, I thought he had bonded out. I did not expect him to be. Showed that he had bonded out because one of the charges that revoked his bond was null prost, but I looked at the document, it said his bond was revoked in court based on a new charge, but then I looked at the new charge was null pros. That's what it said on the clerk's website, so.
I'm looking at on August 3rd, he was at first appearance for what ultimately is 26 CF 1519, at which time the first appearance judge revoked his bonds on 26 CF 827 and 24 CF.
My case. Is it 1519 or?
It's hard to read. It's oh, 1561. I don't see where that case has been null-prost.
My case hasn't been null pros, but.
No, I'm sorry, that the newest case for which his bond's been revoked has not been null-prost. So that's why he's in custody.
And I don't know if I'm going to get the new cases or who's going to have the new cases. I did see the PD filed motions to withdraw. I don't know if RCC has filed a motion to withdraw yet. But I did ask Mr. Nopes to ask the court to continue it until the October pretrial. And the notes I got back from Mr. Nopes were that the court did continue his case to the October pretrial.
I thought I'd just put him on today because he was in jail. I can give you the October pretrial.
I'm asking for that.
Okay. October 28th at 9 o'clock for the cases that are currently on the docket, which is the 827 case and the 24 CF 1561. It looks like I've appointed RCC to his case, but they have not yet filed a motion to withdraw. Obviously, if they do, I would have you appointed next, Mr. Cobb.
I've been keeping track of the facts just in case.
All right. October 28th, 9 o'clock. All right, thank you, Mr. Cardell.
Stephen Smelly?
Smelly.
Judge Stephen Smelly, and 26 CF 937. I've spoken to the state about this case. We're trying to come up with a resolution. I'm not going to ask for continuance. I'm going to ask that it remain on Monday's docket day, but with no subpoenas, just.
It'll actually be Tuesday, just so you know, docket day. Tuesday, September 1st. I'll just call it plea or continue.
Yes, sir.
All right. All right.
Mr. Odom.
Judge Jason Cobb on behalf of Mr. Odom and 26 CF 519. The docket has Mr. Nopes listed as his attorney in the 719 case, but I did see an order appointing me in the 719 case. So
I think I reviewed them both, and both have you as appointed now, but one is still listing Mr. Nopes. Did you say it was the 7?
I think I have the
718
519.
number?
Mr. Nopes has the 719.
718.
718, yes.
But I signed an order on July 10th, allowing Mr. Nopes to withdraw and you being appointed, so they're both yours.
Yes, sir. And I've talked to Mr. Odom. I don't want to ask for continuance right away. I would like to leave it on Tuesday's docket so I can contact the state and see if we can possibly resolve it. But that would be a plea or continuance. And I've spoken to Mr. Odom about that.
And are you aware of the new misdemeanor case? Looks like Mr. Klein's has it right now.
If you can tell me-
26 MM 2082.
I wasn't aware of that one.
It's just from August 5th or so. Appears to be 5 counts of violating the same injunction.
What's that case number, Judge?
26 MM 2082. And that would have been the reason for his bond revocation, although he was already in jail at the time. He has no bond.
RCC has the misdemeanor
Has
case?
the misdemeanor.
Well, hopefully if we can resolve it on Tuesday, we could wrap that in.
September 1st, 9 o'clock. Please continue. All right.
Those are my cases.
All right, thank you, Mr. Cobb. Anybody else out in the audience y'all want to call? Mr. Maddox?
Not that I have, Your Honor.
Still have two inmates represented by Mr. Maddox that I understand there's family here for.
Okay, let's call.
Brooks And Denman.
Denman, Brooks.
And then everybody else, I don't think that the inmate you're here to see is on property yet, so it'll be the first one up whenever we come back.
That's Brooks? That's the family?
Sorry, Caleb Brooks. Somebody here for Seth, I don't know if they're brothers or. They are. They are, so you hear both of them? Can you get both Crooks, please? Your name is? Caleb Brooks. Come on out, please. Stand on that blue, that's okay. This is Caleb Brooks.
Yes, sir.
All right, 26 CF 966.
Yes, sir, Your Honor. It's the first time up. I am asking for a continuance in the case.
10/28, 9 o'clock.
Seth in here? Come on, we got work to do. Stand on that blue, that's okay. This is Seth Brooks.
Your Honor, this is Mr. Crooks before the court in 25 CF 696 and 25 CF 697. Your Honor, he's back from the Florida State Hospital. I believe we found him competent to proceed last time we were here, just turned him around on this quick pretrial conference docket to see if we could get anything done. Your Honor, I am in contact with the family and the alleged victims in this case. I'm going to see if we can resolve the case, but if not, I'll get deposition set, Your Honor.
When would you like it set?
If we could have the next pretrial conference date, Your Honor.
On both?
Yes, sir, Your Honor. Oh, one other thing I do want to bring to the court's attention. Although he appears to be doing fine right now, I don't know if you had the benefit of seeing Ms. Varela's report. She didn't indicate that the jail has changed his medication. To my knowledge, we have no apparent justification for that. The court did previously order, I believe, for him to be maintained on that medication regimen, barring there being some legitimate medical reason to take him off of it, you know, if he were overdosing or something, or it was causing complications in his system. We've received no such justification. Now, Mr. Crooks does appear to be doing fine, and Ms. Varela indicates he's doing fine right now, but it was something I wanted to bring to the court's attention, as it could cause complications in the future.
And it looks like that was just filed yesterday, so I didn't see it when I looked through it yesterday, so it may not have, yeah, it was filed yesterday at 5:22 PM.
Yes, sir, Your Honor.
So,
And I'm not asking the court to do anything at this point, but I am going to be looking into it, and if it does cause an issue, I'll put it back in front of Your Honor.
please do. I would also suggest talking to the jail to see if it can be something that's done outside the court's attention.
Oh, of course, yes.
If that would fix it faster, because obviously it just, sometimes it does. So, all right, but we'll put his cases on 10/28 at 9 o'clock. If you have some sort of resolution that can be brought up earlier, I'll certainly take it.
Yes, sir, Your Honor.
All right, thank you.
Stay in touch with me, man. Write me if you issues.
Let me see, Denman.
Yes, sir, Your Honor. Delma Denman, 26 CF 288. Hey, Mr. Denman. Your Honor, if we could set this on September 1st for a clear trial situation. I've taken Mr. Denman's situation. We've relayed a counteroffer to Mr. Mall, which he is currently looking over. Optimistic of a possible resolution, but can't say for sure, so clear trial.
State ready for trial.
As far as I know, yes, Your Honor.
Okay, well, let's find out for sure on September 1st, 9 o'clock, plea trial.
It was not what I was anticipating was going to get set.
Oh, I understand.
I'm pretty sure I can do it.
We'll talk to you about it next Tuesday. Is that everyone as far as family members who were?
Judge, I've got somebody who's out.
Okay.
He had gotten out of jail and showed up today. He wants to enter a plea. So.
Okay. Do you have his plea ready?
Mr. Seek is signing it now. Mr. Meeks, come on up.
Jalen Meeks?
Yes, sir, Jalen Meeks. It's going to be 2026 CF 1012. And just so the court knows, he scores 35.2 on a sentencing guideline, so this is the guideline sentence.
35.2 points.
Points or months?
Points or months?
Oh, I'm sorry, points.
Okay. And you don't have any objection to the score sheet, Mr. Williams?
No, I don't. So, looks like Mr. Seek signed in my spot.
Oh, apologize.
All right, you got to go work over there now.
It's a conflict, Your Honor.
I did for a long time. I've done more things.
All right, Mr. Meeks, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Jalen Meeks, January 14, 2006.
Okay, and Mr. Meeks, you're here in 26 CF 1012, where you're currently charged with organized fraud, 20 to 50,000. That's a second-degree felony, punishable by up to 15 years in state prison. Grand theft auto, third-degree felony, 5 years maximum, and unlawful use of a two-way communication device, third-degree felony, 5 years maximum. Do you understand that?
Yes, sir.
All right, I've got a plea and sentencing agreement between you and the state that calls for you to plea as charged. It'd be a withhold of adjudication, 3 years of probation, waive cost of supervision, reserve jurisdiction to determine that amount for a period of 90 days, $515 in court costs, and $150 PD fee. Is that your understanding of the agreement?
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right, state, is that your agreement? Since you've signed for both sides already?
Yes, Your Honor. You did mention restitution reserve, Your Honor?
Determined with 90 days reserve jurisdiction.
Thank you, Your Honor.
All right.
Yes.
All right, Mr. Meeks, did you have enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
And are you satisfied with your attorney's representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, not at all.
Okay, and are you currently suffering from any mental health issues?
No, sir.
All right, and has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I read to you?
No, sir.
You understand if you enter this plea, there won't be a trial of any kind?
Yes, sir.
You understand you're giving up your rights to, your trial rights, which are on page 1 and page 2 of the agreement you signed?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, based on all that, Mr. Meeks, what is your plea as charged?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Withhold adjudication, 3 years probation, concurrent between all 3 counts. I'll reserve jurisdiction for purposes of determining the amount of restitution for 90 days, $515 in court costs, $150 PD fee. Mr. Meeks, there is a theft charge, so I do need your fingerprints, and then talk to probation, who's sitting there behind you. And then you have 30 days to appeal the judgment and sentence of the court. And this is a guideline sentence, as Mr. Meeks scored 35.20 points. All right, thank you, Mr. Meeks.
Yeah, you go over there, you're gonna take your fingerprint.
All right, anyone else that y'all have in the audience?
I'll confirm the family that's here.
Okay. All right, sounds like that's all we have as far as the people who were here. What we're going to do is it's 12:25. Is 1 o'clock good enough for y'all? Heather? Heather, you good with 1 o'clock?